or any other day next week?
16.
Friday.
All right, 16.
Obliged.
May it please, but I pray for listing of a writ petition. It was last posted in the month of November 2023 for admission, Lordship. Third week of February, any day, Lordship.
Not 13.
Lordship.
Have it on 16.
16th of February.
Yes,
Lordship. Obliged.
Lord, I beg to mention item number 47, my.
47.
I pray for adjournment of the day for the day, my.
47 at the request of
47,
learned counsel for the petitioner. You're for the petitioner.
my lord.
Matter stands adjourned for 1 week.
On next week, my lord.
Yes, 1 week. Yes.
Obliged, my.
May I please, your lordship, I beg to mention for listings. One matter is pensionary benefit and another is salary, in arrear salary. So matter may be come up admission on 16th of February.
Have it on 21st.
Obliged.
May I please, my lord, I beg to mention item number 37, my lord.
37.
Yes, I am appearing for the petitioner, my lord. I pray that this matter may come up after a week, my lord.
Item 37 at the request of Mr. R.S. Misra. You're Mr. Misra.
I am A.K. Gupta, my lord.
Sorry.
I'm-
DK
Gupta, my lord.
Gupta.
I'm mentioning-
Matter stands adjourned for 1 week.
My lord, I have one another prayer, a writ petition for admission in the next week if possible.
21st.
21st. Obliged.
The consent of the other side, your lordship, I beg to mention item 12. Your lordship may adjourn the matter for 2 weeks, your lordship.
Lordship, I am for the petitioner, my lord. This matter, my lord, a fixed date may be given, my lord. On 19, my lord,
No, no, no. Not like that. If it is 2015 matter, you have agreed for an adjournment. Why?
lordship,
But the previous counsel, the leading counsel in this matter, your lordship, senior is no longer there in the matter, your lordship.
21st. On 21st
Obliged.
February.
Obliged.
Manager, everyone paying for listing for two cases, my lord, and similar in nature, my lord, on 21st, my lord, for admission.
What matters?
My lord, pay parity, my lord.
Pay parity.
Yes, my lord.
Pay parity. Right, let it be on 28 February.
Obliged.
Lordship, pray for listing this matter on 16 February.
What matter?
It's a suspension matter, Lordship.
Suspension. All right, 16th.
May
Four
please,
matters.
Lordship.
Yes, 16th.
may please, lordship, I beg to mention for listing of two matter relating to pension, lordship. The matter was last listed on September 2023.
Right, 16th. 16 February.
Obliged, lordship.
May I please, lordship? Lordship, I beg to mention item number 29, lordship. So matter will pass over, adjourn for the day and pass over, and then maybe listed on next week, lordship. Have
Who
to-
you are mentioning on whose behalf?
For petitioner, lordship, I am for
Who
petitioner.
mentioned the matter? It's by order. So listed at the
Lordship,
request
lordship,
of.
I have to take some instruction from the petitioner,
All
lordship.
right, item 29 at the request of learned counsel for the petitioner, list after 2 weeks. Yes.
Much obliged, much.
I beg to mention for listing, my lord, WC 6517, my lord,
For
for my lord, admission, my lord.
what matter?
Yes, my lord, matter relates to non-payment of arrears salary, my lord. It was last posted on 2nd November, my lord.
21st, yes.
May I please, your lordship. Lordship, I beg to mention item number 51 and 52. We have taken the consent of the other side as well. Lordship, may kindly grant us 3 weeks time to file our affidavit in opposition.
51, 52 at the request of the learned counsel for the respondents.
Yes, Lordship.
Matter stands adjourned for 3 weeks. Consent is a counsel for the petitioner does not object to the prayer made.
Please, your lordship. Lordship, kindly a date may be given, lordship.
Let them file first their affidavit. Then you mention we'll fix a date. All right.
Obliged.
May I please, your lordship? Item number 65, matter may be allowed for withdraw, my lord.
65.
For the client's
No, you wait. It will be called up. You wait. Matter will be called up. Yes.
Your lordship, I beg to state item number 56.
Hmm.
Pair for 3 weeks a time adjournment.
Item 56, you're mentioning on whose behalf?
Mr. T.R. Gogoi.
Huh?
T.R. Gogoi.
Respondent.
Yes.
Who's for
1, 2, 3.
Who's for the petitioner? You have to inform the petitioner
Yes.
counsel.
Yes. Yes.
Yes, what? You have informed.
Yes, yes, Your Lordship.
Item 56 adjourned for 3 weeks at the request of learned counsel for the housing board. It is submitted that consent of the counsel for the petitioner has also been
May I please,
obtained. Yes.
may I please, Your Lordship, item number 62. Kindly adjourn the matter today because my senior is out of station.
Item 62 adjourned for 3 weeks.
Interim order will continue, my lord.
Whatever is there is there. 62. If it is there, it will continue for 3 weeks.
May I preview your lordship, item 39 and 40 may kindly be adjourned for the day, lordship.
39 and 40.
40. I'm for the respondent ASTC,
39, 40.
lordship.
Have you informed the council? for the
Lordship,
petition?
my junior will be there, they will inform, lordship. I have some personal difficulty, lordship. My maternal uncle expired, lordship. I have to attend their funeral, that's why, lordship. They
But
will
you
be
should
there.
have you informed?
Lordship, they will, lordship. They will be
Item
there.
39, 40,
40.
at the request of Mr. R.M. Das, appearing for ASTC, matter stands adjourned. It is submitted that consent of the council for the petitioner has also been obtained.
Lordship.
Yes.
Deeply.
We do. Yes, 65. It is submitted by learned counsel for the petitioner that the writ petition is not required to be pressed as per instructions received from the writ petitioner. Accordingly, the writ petitioner stands dismissed on withdrawal. Interim order, if any, stands vacated. Mr.
A Kundu, Lordship.
A.
Kundu.
Kundu appears for LIC.
Yes, Lordship.
Okay. Your name, please?
Bidas.
B. Das for the writ petition. Yes.
May please, Your Lordship. Lordship, in this case, by the last order, we are directed to produce the advertisement. We have tried, but I could not collect the advertisement. Probably it will be with the respondent because the call letters, only the appointment letters we have provided.
Yes. You are for NC Hills.
Lordship, I am for the NC Hills.
Advertisement issued by whom? NC Hills.
Yes,
Is there any advertisement by which these petitioners were appointed?
Lordship, I have to take the instructions, lordship.
Mr.
Lordship,
S. N.
this may be
Kamuli,
issued
learned
because-
counsel for the petitioner, submits that in terms of the earlier order dated 7/8/2023, an additional affidavit has been filed. However, the copy of the advertisement through which they had applied for the posts of assistant headmasters and assistant administrators, as well as the call letters by which they were asked to appear, are not available with them. Where Mr. R.M. Das, learned counsel for the respondent,
Dimahasa Autonomous.
Dimahasa Autonomous Council, will complete his instructions in this regard. And praise for time. Matter be listed after 3 weeks. What about call letters?
Lordship, call letters also they do not have.
Then
Because actually they were promoted on ad hoc basis, what I can be.
all right.
And they will allow to continue.
Mr. Das be furnished with an extra copy of the writ petition.
Not notice may be issued, notice.
No. Not in view of this order.
Yes,
You have not complied with this order.
Yes, Lordship, that is.
So you comply with this order.
Lordship.
Otherwise, we would have dismissed it.
Yes.
Extra copies be furnished within the course of this week.
Lordship. Deeply.
May it please, Your Lordship.
No implement file.
Let's say, yeah, I don't have any grievance against the personal department. It was the understanding of. Lordship,
But
kindly-
your prayer is recorded.
It's really not my. Lordship, kindly say the prayer and the grievance of the petitioner. He is claiming for notional benefit against the elementary department. The matter was under active consideration. In the meantime, Lordship, he retired. Now juniors have been given the benefit. Lordship may kindly have.
Why is the personnel department required?
Probably, Lordship, the Lordship kindly see the annexer, there is one annexer, Lordship, kindly come to. Because there is a. Yes. Annexer 22, page 70. The file was endorsed to, Lordship, kindly come,
Annexer 22.
Annexer 22, page 70. Probably this was the understanding, Lordship. May I read, Lordship?
Oh,
In inviting a reference to the subject cited above, I am directed to inform you that due to the unavailability of service rules for planning and statistical personnel under Director Elementary, the promotion process could not be initiated in respect of the petitioner so-and-so, so-and-so. As framing of rule is taking time, the department had processed a file number so-and-so for framing service orders for elementary education planning and statistical service orders 2022 to facilitate the promotion process of all eligible candidates, including the petitioner of this case so-and-so. The file was endorsed to personnel department on 22 for vetting the draft service order, and personnel department returned the file on 24/5 so raising some queries. The matter is under process for framing finalization of the Assam Elementary Education Planning Statistical Service Orders 2022, and upon approval of the same, the promotion process will be given effect to in compliance of the Honorable High Court order dated so-and-so, so-and-so. You are therefore requested to inform so-and-so, so-and-so. But in the meantime, Lordship, that was, Lordship, they have given the approval and juniors have been promoted. But in the meantime, Lordship, I'm retired from service, now claiming for national benefit, Lordship. Probably this was the reason for personal grievance, but I don't have any grievance against it because already personal department has given the approval and promotion order is also issued. Lordship may kindly come to page 25, so page 74, annexure 25. This was the promotional orders who have been given to my juniors from serial number 13 to 18.
page?
Page 74, last annexure, annexure 25. This was the consequential promotional order in view of the service orders of 2022. All are of the Lordship statistical assistant and planning assistant, but my grievance is from serial number 13 to 18. From the common gradation list, I was senior, Lordship. 13 to 18, they have been given the promotion. But in the meantime, I retired, Lordship. And now I claiming the matter was under active consideration. And
You were not given the promotion
not given the promotion benefit.
because the rules were not there.
No, not there. But the authority admitted that since rules, it will take some time. Therefore, service orders will be framed. So accordingly, service order has been framed in 2022.
And when did you retire?
May 2023. 28th of February 2023. And they have given the assurance that is the only annexure 22. Then page 21. In view of the earlier court order, they have so
Yes,
the
Mr. Sharma.
vacancy position also.
As the petitioner has already retired, Lordship may issue notice, we will verify.
Third Learned Counsel for the parties. Mr. Dekha, Learned Counsel for the petitioner submits that implement of personnel B department as respondent 4 is not necessary, as the prayer made in the writ petition is claiming for notional benefits, which according to the petitioner are entitled to him as his case for promotion was not considered during his period of service. Petitioner superannuated on
28th of February 2023.
28 February. 28.
Yes,
28th of February 2023, and the promotions effected to the next higher post, in which several persons who were junior to him in the gradation list were promoted, was issued on 31st of May 2023. The grievance of the petitioner is that during his service period, his case ought to have been considered for promotion to the next higher post of
Assistant Planning Officer.
Assistant Planning Officer.
Annexure 21 and Annexure 22. This was under active consideration, but because of the
All right.
negligence.
Issue notice returnable 4 weeks. Mr. T.N. Sharma appears for
For 1 and 2, Lordship, no, 1 and 2. And finance is
Yes.
for one in Mr. Who's appearing for finance?
Google is, I will inform you. Copies are
Echolia, Mr. Echolia is there, Lordship.
Huh?
Otherwise, Mr. Echolia is there.
You are also there.
No, Lordship, I can appear on behalf of P. Gogoi, Lordship.
All right, Mr. B. Gogoi appears for the respondent number 3. Since the standing councils represent the respondents, notices are waived, however, extra copies be furnished within 1 week from today.
Lord. Okay. Obliged.
May please,
Yes.
Lordship. Lordship, by order dated 13/9/2023, this court directed us to submit an additional affidavit placing on record individual orders of regulation of the service of the commissioner. My lord, we did that. After that,
This is similar to the series matter of
Yes,
series matter of that whole series of BTC regulation has been down of 1216 questions, my lord.
Lord, and in that particular case, notice was already issued. That is, my lord.
All right, heard learned counsel for the parties, issue notice returnable. When is that matter fixed?
Lordship, you are not fixed. It is, it was last listed on 1st
After
of February,
4
after 1 month, 4 weeks it will come.
Grievance of the petitioner is for prayer before this court is for release of salaries to the petitioner from the date of regularization for the period 1/1/2005 to 22/2012, 22/12/2014. So, there are Mr. S. Bora, learned counsel for the respondent PTC, submits that series, a bunch of writ petitions on similar issues have been filed, and this writ petition may be listed along with those bunch of writ petitions. So accordingly, that notice be issued. Returnable 4 weeks. Mr. P.N. Sharma appears for
I am for 1 and 4, Lordship.
1, 2,
2,
1, 2, and 4.
1, 2, and 4, Lordship.
Mr. B. Gogoi for finance, number 3.
Now 3.
Mr.
I appear for 5 and 6.
S. Bora for 5,
and
6. 5 and 6. Let the writ petition be listed along with, do you have the number?
Yes, my lord. 5281 of 2016.
5281 of 2016 and other connected writ petition.
My lord, on last occasion, my lord, my name was wrongly reflected. My lord.
You are Mr.
D. Bora.
D. Bora.
It was reflected as Miss D. Bora.
Okay, Mr. D. Bora.
Obliged.
Counsel for the petition.
May I please? My lord, in this case, my lord, in this case, I am to file additional affidavit, my lord. It is ready, my lord. 1 or 2 days may be allowed, my lord. It may be fixed in next week, my lord.
Yes. At the request of Dr. P.K. Goswami, matter be adjourned for 2 weeks.
No, my lord, 2 days, my lord.
Be listed next week. Mr. D. Upamanu appears for the respondent.
Highly okay.
May to lordship. Issue here is, my lord, the old pension scheme would be covered to the petitioner or not, my lord. This is a second round of litigation, my lord. The earlier order is page 153, my lord. Annexure 8. And relevant portion is page number 172, my lord.
All right, who is appearing for the respondents?
PTSD.
You serve copies, let them get their instructions. You are there? You're appearing?
Yes, madam.
Mr. V. Kumar for the petitioner, Mr. Odikari for respondents.
All respondents.
All the respondents.
Then at council, CGC for the respondents will obtain instructions in the matter.
Right.
List after 2 weeks.
Right.
Extra copies, if required, be furnished on the respective standing councils.
Right.
Okay.
Declare your lordship.
In this case, my lord, the petitioner earlier approached this honorable court, and this honorable court, my lord, by order dated 17/1/2013, 2023, my lord, page number 33, has directed the
Page number
33. Operation
33.
33, my lord, the order. To release the salary of the petitioner, my lord.
What is the direction?
Direction, my lord.
Page 33.
To allow the petitioner to work.
It is also made clear that if the petitioner had been working at center number 80 in ward number 5, she shall immediately cease to do so
Now,
and
what has happened after that?
After that, my lord, inspection report, my lord, page 34, my lord. My lord, by the supervisor. Supervisor has given that I am working in the said school, my lord, where Anganwadi center, where I am supposed to work, my lord. But
Where is that?
page 34, my lord. Annexure 7A.
Okay. Then
As of now, payment has not been made, my lord.
why second writ petition?
They have filed one, my lord, passed an order in compliance of the order, but they have not followed, my lord.
Where is that order?
Letter 38, my lord. 38. Simply they have passed this order, my lord. CDPO. He is retired.
Yes, what do you say?
Lordship, petitioner's grievance is for not release the salary, Lordship. As per the earlier order, Lordship, in our affidavit, Lordship, it is stated in the para 3, Lordship, page 32, Lordship, some anomalies, public complaints are received, Lordship. That's why her salary was
No, but there is a direction of the court.
not released, Lordship.
There is a direction of the court.
Direction of the court, Lordship. Yes, they have complied the order, Lordship. The respondent authority has complied the order, Lordship.
Salary
Page
release.
38, Lordship.
38.
Page annexure 38, annexure at 8A, Lordship.
Page 38.
30, page 38, Lordship. And further, Lordship, we will obtain instruction, Lordship. Address in this is the Lordship.
No, but why have you filed a writ petition? There is already an order.
Order, my lord.
Why another writ petition?
My lord, in the name of compliance, my lord, they have issued the order dated page 38, my lord. But in fact, the salary has not been released. Order is issued.
Salary not released, you file contempt. Why have you filed a writ petition?
Writ petition, my lord, because they have thereafter issued the shock cause notice also, my lord.
Lordship, that's why, Lordship, I am stated, Lordship. In earlier than writ petition, Lord stated, respondent authority clearly stated, Lordship, the public complaints were received, Lordship.
Okay, heard counsel for the parties issued notice returnable 4 weeks. Mr. A. Chakraborty appears for
all the respondents.
All respondents. Notices are waived, extra copies being furnished within 1 week.
But the pendency may not be a bar, my lord. This objection.
Not required, not required. If they have not, if it was not a bar, you would not have come to the court for the second.
Just. Public.
May I please, Lord?
One minute. Yes.
May I please, Lord? My lord, the petitioner before your lordship claiming the UGC scale, my lord. Earlier, my lord, the two writ petition was filed by the writ petitioner for his regular appointment. Subsequently, in 2018, he was appointed against vacant sanction post. That is annexure 19, my lord. Page 60. Conditional order was passed, my lord.
Page 16.
160.
60.
My lord. Annexure 19, 19. Therefore, my lord, his PhD degree has not been considered at the time of appointment. Similar two case, my lord, pending before this honorable court.
First, tell your case. What
My
is
lord.
your matter? Forget about
lord.
similar matters.
My lord.
Why don't you address your issues here? Then, if similar matters are there, then you wait for the similar matters to be disposed of. Then your matter can be covered. What is he? He's appointed now.
My lord, finally appointed on 25/4/2018, my lord. By this order, my lord, annexure 19. Subsequently, they are inserting some conditions. And
Where? Which conditions?
page 60, my lord, condition, terms and conditions.
60 is okay, 60.
Condition 2, my lord. In between, my lord. The incumbent concerned will be required to qualify in NET SLATE PhD within 2 years. Otherwise, her service will be discontinued, and till then, she will be entitled to get fixed basic pay as prescribed only from the date of joining subsequent to this order.
Now, after this, what happened?
And subsequently, my lord, his fixed pay again enhanced to 55,000 in 2022 after filing representation. But
No. Your grievance is that you had completed some PhD.
yes, my lord.
That has not been taken into account.
Yes, my lord.
Now, when did you complete your PhD?
2016, my lord. Before
16.
16.
Now you are appointed with condition number 2.
Yes, my lord.
Now, in spite of, where have you submitted that you have completed your PhD?
Immediately before appointment, my lord.
Yes. No, after appointment also?
After appointment also, my lord.
Then?
That is a representation, my lord, here. Representation, my lord, page 66, annexure 22.
Yes.
Lastly, in 2020, it is filed.
But you are still working.
Yes, my lord.
Your termination is
No. No.
You have not been terminated.
No, my lord.
But you're not been given the full pay.
Yes, my lord.
Yes, Mr. Upamanyu.
Lordship, I'll obtain inspection, Lordship.
You say some matters are pending.
Two matters are pending.
Pertaining to the same university.
Same university.
Which university is this?
Singhania University, my lord. Jhunjhunu, Rajasthan.
Okay. So it is not recognized.
My lord.
Yes, Lordship.
Do you have the numbers
Yes,
of the writ petition?
Writ petition, my lord, 4721 of 2021.
Then I think UGC is also a party.
Yes, Lordship.
Who
Yes,
appears for UGC?
Yes, party is there.
Okay, hired learned counsel for the parties. Grievance of the petitioner is prayer before the prayer before this court by the petitioner is that his PhD degree, which he obtained from Singhania University in the state of Rajasthan, is not accepted by the authorities concerned, and he has not been, although appointed as what? Assistant professor in the Department of Nepali, Jagbir Hem Borua College, Sonitpur. He has not been given the pay and allowances as per the rules. As the PhD acquired by the petitioner has not yet been accepted by the authorities. Stop. He has submitted a representation before the authorities as far back as 16th October 2020, which according a representation before Director Higher Education, which according to the writ petitioner has remained pending. No decision is was forthcoming. Therefore, present writ petition has been filed, seeking appropriate directions. Where I issue notice returnable 4 weeks. Mr. T. Upamanyu appears for 1 and 2. Steps on respondent 3, 4, and 5 by usual course and registered post AD. Trustee is also permitted. Let the matter be, it is submitted that there are similar writ petitions pending. Let the matter be listed along with WPC 4721 of 2021.
Obliged, highly obliged.
Please, Your Lordship.
Yes.
My lord, we are the physically handicapped persons, my lord, and family pension has been receiving, my lord, our stepmother, my lord, but neither the government nor the stepmother has been provided our share, my lord. This is my case.
You are who? Who are you?
My lord, we are the dependent of the deceased government employee.
In what way?
My lord, we are the son and daughter of first wife,
Son and daughter.
my lord. Now family has been, pension has been receiving our stepmother.
Respondent 7.
Respondent 7.
Number 2 is not eligible for pension.
We are the disabled person, my lord.
Huh?
We are the disabled person, my lord.
Both.
Disabled person.
Both are disabled.
My lord, my lord.
Where is your certificate?
My lord, page number 20 and 21. '19 also, my lord. This week, sir.
%.
21, my lord. 75%.
What is your name?
My lord,
Petitioner 1.
petitioner Benjir Sultana, my lord.
And number 2.
And number 2, my lord, Mansur Arafat Ahmed.
And you have another set of brother and sister.
My lord, my lord. These are major, my lord. Physically able and
Yes. 143 amendment.
My lord, the petitioner number 1, my lord, says 10% only the physical disabled. As per the provision, my lord, she is not entitled. And regarding second, my lord, petitioner
No,
number
but
2, my
if
lord.
she is unmarried,
My lord,
unmarried,
then she has the right. But that mother have to, my lord, take care of that, my
that's right.
lord. Then she is, although she is stepmother, right now she is lawful wife, my lord.
She has to look after under provision amendment to 143.
My lord. And regarding my lord, petitioner number 2, my lord, although his physical disability has been shown as 75%, but as per the provision, that certification has to be come from the medical board, my lord, not from the medical officer, my lord.
I think there is a certificate.
And certificate, my lord, page number 19, one certificate, my lord.
No, there has to be a certificate like,
From the board, my lord.
this one, page number 19, yes.
19.
But this is with regard to the petitioner one.
One.
For two, you don't have.
And two, my lord, certificate is not there, my lord.
Now that certification has to be there by the disability medical authority.
Disability certificate will be a medical board duly constituted by the central or state government.
And my lord, only page number 24 also, my lord. He is unmarried and unemployed, my lord.
Your late father was working under which department?
Elementary, my lord.
Elementary.
Elementary.
Now respondent number 7 is receiving.
My lord.
That is page number 18, my lord. That one is receiving from 2017.
We'll issue notice first. Let us issue notice.
My lord.
You take steps on respondent 7 if required by Dusty also. Heard and counsel for the parties issue notice returnable 4 weeks. Mr. P. Soikia appears for respondent 1.
1 and 4, my lord.
1 and 4.
My lord.
Accountant General. MS so and so appears for respondent number 2. Mr. Cholia for respondent 3 and 6. Mr. Khatonier for respondent 5. The notice on respondent number 7 be issued by usual course and registered post. Dusty is also permitted. List after 4 weeks. Since the learned councils have represented the other respondents, notices are waived. However, extra copies be furnished within 1 week.
Obliged.
May I please, your lordship? First, here the husband of the petitioner was a master role employee since 1983. Subsequently, his services were regularized in 2001. So after completing 1 year and 5 months of regular service, he passed away, lordship. He died in Harnett. So lordship, after that, the petitioner made representation to the authority, respondent number 4, but she has not been receiving her pension.
Where is her documents, relevant documents?
Next of kin certificate is on page number 14, lordship. Next of kin certificate.
Wife.
Page 15, lordship. Bahagi Wala, wife.
So what is the length of service?
Length of
17
service,
years.
Yes, lord.
What is the requirement under the rules?
Lordship, under rule 140, lordship, in case of death in harness, lordship, 1 year of regular service is necessary for entitlement of pensionary benefit to legal heirs of the deceased.
Yes, Mr. Dhor.
My lord.
Get your instructions here.
My lord, the thing is that my lord will issue notice.
Okay, heard learned counsel for parties issue notice returnable 4 weeks. Mr. R. Dhor appears for respondent 1, 2, 3, 4. Mr. P. Soikia for respondent number 2. Accountant General MS. You have to speak a little louder.
A Lala, my lord.
A. Lala for respondent number 5. Since learned counsels have appeared, notice is waived. Extra copies be furnished within 1 week. List after returnable date.
Item 10.
Item 10 to কি কিবা হল নেকি?
Item, what is this? 10, 11. You wait, I think your file is somewhere little misplaced. Yes, item 11.
In this case, ma'am, this is the second round of litigation, my lord. Earlier, your lordship directed the DEO for consideration of my representation, which was rejected. Your lordship may kindly found your lordship order at page 32, my lord. Relevant direction is page 33, my lord.
Yes.
Page 33, my lord. Considering the fact that the representation is stated to be pending before the district elementary education officer Dhubri, without expressing anything, on merit, this court issues a direction to the competent to consider the representation of the petitioner and dispose of the same by passing speaking order. Thereafter, speaking order is passed, my lord. Your lordship may found it at page 37. Petitioner is a physically disabled person, my lord. Page 37 is a decision, my lord. From the above circumstances, it is decided that the school where he was transferred, allowed to work, is 1.6 kilometer from his residence as per Google Maps. And
What is the earlier order?
Earlier order is at page, my lord. Transfer order, my lord.
No, you refer to a 32. 32.
32, my lord.
No, what is your prayer now?
My prayer, I am challenging that order, my lord, that impugn order
Why?
2004, my lord.
Why are you challenging this order?
My lord, since my lord, Google Maps shown, my lord, I have also annexed the Google Maps, my lord, at page 38, my lord.
Where is the order you are challenging? Page number?
Page number, my lord, starts from page number 36, my lord. Annexure 10. A relevant part is page 37. That is his decision, my lord.
Now, what according to you is a good place to work?
It's from 2.6 kilometer, my lord. I have also annexed the Google Maps, my lord, page 38. my lord.
No, forget the Google map. You are not happy with the school that you have been allotted.
In fact, my lord, it is I restricted movement, my lord, since left leg is totally paralyzed, my lord. So he could not go to at least.
Now, what
6
is the
kilometers
alternative
even
prayer
after
you want? What is your alternative prayer?
that. In my present school, I may be allowed, my lord, and for this, my lord, I have. My prayer is.
Why have you been transferred? Where is the transfer order? Where is the transfer order?
My lord. Transfer order is at page 24, my lord, annex of 5. For better academic environment, Shyamcharan Kuti MB School, Sri Nurujjaman Kaji, assistant teacher Shyamcharan Kuti MB School is hereby allowed to work at Thaladanga MB School, and Moshomi Sabnath, assistant teacher Thaladanga School is hereby allowed to work at the Matiachor ME School with immediate effect.
Where is it located?
My lord.
Where is the school located? The earlier school, present school?
That is my present school, my lord.
Where is it located? Where is it
That is
located?
located within my village, my lord.
What is your village?
And from my residence to the transferred school is almost 3 kilometers, my lord, and ups and down it will require 6 kilometers, my lord.
No, but it is not a case that you are immobile. 3 kilometers you can go.
My lord, in fact, my lord, I have as per under the 1995 Act, Pedagogy Act, the locomotor disability, they are, my lord, restricted movement, my lord.
Where is that certificate of locomotor disability?
That is at page, my lord. Page 18, my lord.
18.
Annexure 1. There is an identity card, my lord. And original one is at page 19, my lord. Type copy is at page 18. 50% locomotor disability. And central government also issued, my lord, another identity card, my lord, this is page 20, my lord.
This is Aadhaar. Is it Aadhaar? No. No, but is there a ground, is there any, are you relying on any provision of law to show that people with disability cannot be transferred?
My lord, in fact, my lord, I have also annexed the central government office memorandum. my
Yes, where is it? Page number? Page number?
lord. Page 42, my lord. Annexure 13, my lord.
Yes.
Last, my lord, part, my lord. However,
So kindly read the whole thing.
page 42, my lord.
Please read the whole, it's a short.
The undersigned, yes, my lord. The undersigned is directed to say that a suggestion has been made that physically handicapped candidate appointed under the government should preferably be posted in their native place or at least in their native district. The matter has been examined carefully. It may not be possible or desirable to lay down that physically handicapped employees belonging to Group A or Group B who have all India transfer liability should be posted near their native place. However, in the case of holders of Group C or Group B posts who have been recruited on regional basis and who are physically handicapped, such persons may be given posting as far as possible subject to administrative constraints near to their native places within the region. That sentence is clear, my lord, that they should be posted within their native places.
Yes, Mr. Khatuniar, I think we may need to examine this.
Yes, ma'am. Case 30 is the order, my lord.
30?
He earlier approached this honorable court. This honorable court
Yes.
pleased to direct to dispose of the representation.
Right.
The order by which the representation was disposed of, my lord.
Yes.
My lord, the ground taken in the representation is, my lord, the petitioner mentioned in his representation that he is 50% locomotor disabled person. He could not walk appropriately. His working school, Saraldanga MBS, is distance from his native village. This is much communication disturbance between his residence and school. Flood in rainy seasons becomes serious disturbance between his residence and the Saraldanga MBS. He stated that without physical assistance, it is impossible to attend Saraldanga MBS. He stated that at 18, he was 50% locomotor disabled person, and he is 40 now, become weaker than earlier and more pathetic. He also stated that he has been suffering from various diseases, that is hypertension, leg pain, etc. But after verification about his representation, following points have been noted. Against point number 1, it is admitted. Point number 2, my lord, physically it was found that the petitioner could walk being PW. Doctor certificate issued from Kokrajhar district. Distance from house of the petitioner to Saraldanga MBS is hardly 1.6 kilometers as per Google Map, and the said school is attached with PW road. Saraldanga MBS is connected with good communication metal road. He can drive 2 and 4-wheeler driving license also there, my lord. He can ride 2 and 4-wheelers and common disease or sickness, my lord. In fact, there are several complaints against him also, my lord. Several complaints has been received against the complainant by the SMC headmaster and BEO and other for his misbehavior. He always returns on the plea of being PWD. He several times complains against the headmaster and SMC for his own interest and misuse his privilege of being PWD teacher. Recently, the petitioner was assaulting another teacher in presence of students for which academic environment became pathetic. Both the teachers lost FIR on the basis of leaving for better academic environment. This office decided to transfer both the teachers to other school. From the above circumstances, it is decided that the school
where he was transferred, allowed to work is 1.6 kilometer from his residence as per Google Map, and the school is attached with PWD road. Obviously have good road communication. Even though he is a PWD, his driving license, he has driving license and can drive two-wheeler and four-wheelers. On the ground of representation, his statements are not acceptable. Hence, for better academic environment among the students and teachers to avoid polluted atmosphere, his representation is rejected and disposed of accordingly.
First, from which school is he working now?
Shamacharana Kutti, my lord.
Okay.
And headmaster also submitted report in this respect, and petition are asserted by the said person that in fact from the report, my lord, of the order, as page 30, my learned friend already read out, my lord. It's not correct, my lord. From the report of the headmaster, which I have submitted by annex with this petition as page 39, my lord. He was attacked by another teacher.
82.
Page 39. Headmaster report.
No, but two-wheelers, four-wheelers, he can ride, but is he provided with one by the department?
No, he can drive, my lord.
No, he can drive provided he has one.
Obviously, he has, my lord. That is why he has the license, my lord. Obviously, he has, my lord.
Not necessary. That cannot be the inference always.
No, in any case, my lord, it is not the duty of the department to provide two-wheeler or four-wheeler, my lord.
Therefore, why was it mentioned here? That is
It's
what.
mentioned here because he can drive, my lord.
Huh?
Because he's always always trying to
He can
impress upon that
drive
he is a
provided
PWD, he cannot do anything.
No, there is a finding that he has one, that's a different finding.
Yes, my lord.
The finding is that he has a license.
Yes.
Now, by that license, how will he go unless he is provided with one? There
That
is
I
no
understand.
finding that he has already a vehicle.
My lord, whether he has or not, my lord, that is not mentioned in the order.
That's
but,
right.
But because of he always tries to impress upon that he cannot walk, cannot do anything because of his locomotor disability.
Basically, essentially, what you are saying is that a person with 50% locomotor disability has been given a license.
And
That
nowadays, my lord, there
license
is a
can be granted, my lord.
vehicles are there.
If he is can drive, my lord, then
No, we don't know. In terms of the motor vehicle rules, what is the percentage of disability by which he can be granted? We'll have to find out from the rules. Perhaps the department is trying to project that he is not as disabled as he projects himself to be because he already has a license. But anyway, there is a circular of the government of India where there is some benefit granted to persons with disability.
here, as per this circular, my lord, the director to say that the suggestion has been made that physically handicapped candidate appointed under the government should preferably be posted in their native place. He is posted in their native place, my lord. It is only 1.6 kilometer from his residence, my lord.
No, my lord, 2.6 kilometers as per Google Map. He should,
How far is the present school?
present school is nearby his residence, my lord.
How far?
Almost 500 to 500 meter, my lord.
How does he go?
He told me, my lord, but I have not stated in my petition, but it is within the vicinity of his residence, my lord. That's why there is no problem for him, my lord. Otherwise, my lord, new school, there is a river also, my lord. And I have also stated in my petition, my lord.
No, you have to, these details, you have to bring it on record, number one. Number two, you have to build up your case to say that as a person of locomotor disability, similar provisions are available in the state.
In the state, my lord, there is no such provisions for locomotive.
There.
So that's why, my lord, I have annexed the central,
Right, we will see. Heard learned council for parties. But you will have to go and join. We are not issuing an interim order.
Otherwise, my lord, if he is joined, my lord, it will be a trouble for him, my
No,
lord.
we cannot
My
help
lord,
that.
I pray for your, at least, my lord, your lordship may kindly peruse the Act of 1995 mainly, my lord.
Huh?
Act of 1995, Periodic Act of 1995.
Yeah,
Locomotor disability is there, my lord, in the definition itself, my lord.
Your entire case is based on the decision of the authority being based upon Google Map. You are saying that as per the information given by Google Map is not correct. That is what you are saying.
Is
Can
not
a
correct, in
writ
fact,
court-
my lord, and
Can this court decide on this issue? Your case is not that under the provisions of the law, these kind of orders cannot be issued to persons with locomotor disability. That is not your case.
In fact, my lord, they have also,
You want to point out to this provision, and what provision do you want to point?
Section 2O, my lord. That is definition, my lord.
2O.
Section 2O, locomotor disability. Means disability of the bones, joints and muscles leading to substantial restriction of movement of the limbs or any form of.
We are not questioning that. You have already have a certificate showing 50%. But you have to show that under this, you are unable to perform your duties. And therefore, these transfer orders ought not to be issued.
In fact, my lord, I am.
You have to plead your case in the framework of law for us to pass any orders to that effect. Your only ground is that whatever decision has been decided by the authority is based on Google Map. That's your case.
And another case is, my lord, central notification as well as locomotor disability, my lord. At locomotor disability of 50%, my lord, for restricted movement, my lord. Since, my lord, my present from my village to present school itself is 3 kilometers, my lord. 2.6 and ups and down it will 6 kilometers, my lord. And so far as, my lord, good communication, my lord, nowadays there is
that we are not here to find out. It's a matter of fact-finding authority. Then we had already directed the authority to decide your representation. They've decided. Now you're assailing it. We'll see. But interim orders on this, we are not inclined unless you point out that this is in violation of the spirit of the act or the rules or any provision that you have not been able to show.
In fact, the locomotor disability for purpose of determination, that was not considered, in fact, my lord, in his order, my lord. He also only relied in his decision, my lord, your lordship.
No, it is considered. See, after verification of the representation, following points have been noted. So these are his verification, these are his findings. He is even hinting that notwithstanding your 50% restrictions, you are issued driving license for 2- and 4-wheelers.
In fact, my lord, driving license, my lord, for nowadays, my lord, disabled persons have obtained, my lord, license because of non-gear of the vehicles, my lord. There is an automatic gear, my lord. So they have for only 1 lakh, my lord, that would.
We are not questioning that. We are asking you that these are the findings, and you are challenging it. On what is the basis of your challenge?
In fact,
Only the penultimate finding that he is relied on the Google Map. Whether Google Map is correct or wrong, on what basis does this court arrive at a decision?
In fact, they have arrived
at various times. You will find the distance is, distance and time.
Distance 1.6 kilometers they have mentioned, my lord, but originally that distance is not correct, my lord.
That's what I said. What is the basis for finding out the correct distance? You find out from some authority. You find out what road, what is the road condition, what is the distance. You'll have to find out. Third Learned Counsel for the parties issue notice returnable 4 weeks. Steps respondent counsels, Mr. Khatonia appears for.
And for 1, 2, 4, and 5, my lord.
1, 2, 4, and 5.
3, my lord.
Mr. P. Soikia for respondent 3. Steps on respondent 6 by registered post AD along with usual course. Matter be listed after returnable date. The impugned order shall be made subject to the outcome of the writ petition.
Obliged.
Yes.
Lordship, herein the petitioner was employed as a master roll worker. Subsequently, he was upgraded to a work charge employee, Lordship. Now, his continuous period of service is 35 years, including 18 years, 3 years, 18 years, 3 months as a work charge employee. Lordship, he was employed against the work charge employee against the vacancy. And he retired in 2013, Lord.
You are now praying for pension.
Yes, Lord.
My lord, he is not regularized, then how will get pension, my lord?
No, what is the
He is
stage of
seeking,
the,
he is seeking regularization now, first.
what is the stage of the matter at the Supreme Court?
Oh, that is still pending. Everything on it.
This is, there is some review petition filed, is it?
Yes, my lord. There is a mallet. I have to take the update instructions, my lord, in this regard, my lord.
Let him obtain the instructions.
And Lordship, they have not properly addressed the respondent, also, Lordship. Kindly peruse respondent number 5, my lord.
5.
Test 4.
Document general.
Yes, my lord.
What is the meaning of this? Respondent 5?
Document general A and E.
This should be accountant general.
Principal, it should be principal accountant general A and E, my lord. Account and entitlement. A and E.
Sorry, Lordship, I may be allowed to correct it. No.
Mr. So-and-so, learned counsel for the petitioner is permitted to correct, permitted to file amended course title, giving the correct reference and address of the respondents, more particularly respondent number 5. The amended course title shall be filed before the registry within 1 week from today. Within this week.
Lordship.
Matter be listed next week. We are not passing any orders without the correct course title.
May it be Lordship, before my senior friend starts, my lord, I have a preliminary objection, my lord, on maintainability of this petition, because, my lord, the action complaint of.
Let him begin.
Yes, yes.
We don't even know what his grounds are.
Yes.
Yes, please.
My lord, petitioner was appointed as an writer clerk under the Assam Rifles. My lord, in the year 1987, and now he is in the category of Subedar Major. 36 years he has rendered service. My lord, by the impugned order annexer at page 17, my lord, he has been given transfer from present place of posting at the Director General Assam Rifles at Shillong. He has been transferred to 8 Assam Rifles at Sosod, Manipur. My lordship will find at page 17. The last person is the petitioner, MC Das. So he has undergone an angioplasty operation. He is heart patient, my lord. My lord, his contention is that he has rendered as many as 16 years in heart station and as many as 3 station in moderate heart station. And he being a heart patient and he required a regular medical checkup. So he may be given a place where he can go for regular medical checkup. My lord, he has submitted prior to this impugned transfer order. He has made representation, my lord, at page 18. Because, my lord, before after 3 years, he had to go for another place for on transfer. Then, my lord, he has made this application saying that he may be considered on medical ground and he given 5 places or alternative place of posting. Lordship will find in the category this item under item number 10, present request not more than 50 words. My lord. Sir, I was posted to this Directorate CPBO Assam Rifles in August 2020. My normal tenure will be completed in August 23. Recently, I have been diagnosed IAF with severe unstable angina and had undergone angioplasty at Health City Hospital, Guwahati, Assam. Subsequently, I require visiting the doctors often for checkup. Therefore, I humbly request your honor to please consider my LLP, means last leg of posting. My lord, I am to retire on May 2026. So, last leg posting was stopped as indicated in the 5 places, my lord. But that was returned. That, my lord, it was forwarded by annexer at page 19. Then, my lord, the deputy commandant has returned at page 20, my lord. Application for LLP in so-and-so, under reference is returned here due to following reasons. My lord, reasons A, my lord, indicates that he used to make 5 station alternative choice. Then, my lord,
No, what is A? What is A?
my lord, the application is not considered, my lord.
Why?
They said that we make an other application with alternative places, 5 places, my lord.
No,
Then we have also made.
No, what is the meaning? That it should include minimum 4 to 5 choices stations,
Yes, my lord.
including active what? Battalions.
Yes, my lord. They have said
Should
that
not
we are,
specify any
I am, the
particular
petitioner is to
headquarter.
make further application with some other alternative places that we have made. But this one also, my lord, at page 21, this one also returned, my lord, at page, my lord, at page 23, my lord. Then, my lord, I have made 4 application with alternative place of posting, but not considered. My lord, I am in a difficult situation whether I have to go to Manipur, Sasad, in a very remote and harsh station where from I cannot avail the medical checkup, and I will ultimately I will to die. And then if not considered, my lord, if I go there, my lord, I will die without medical checkup. And therefore, my prayer is that this can be modified and I may be allowed to.
Where is the order of transfer now?
My lord, order of transfer is the annexure 1, my lord. This was the first one at page 17, my lord.
Eight Assam Rifles.
My lord,
Yes.
Assam Rifles, my lord. My lord, my prayer is that I am to return on May 26. Till then, I will be allowed to stay there, my lord.
In the same place.
Same place, my lord.
Your transfer.
Many others.
Your transfer postings are on the basis of circulars for 3
My
years
lord.
or 4 years.
Yes, my lord. But then, my lord, I have given, my lord, 4 times I have given alternative place. Not
Why is it not maintainable?
My lord, Lordship, we kindly come to page, para 3, page 5, my lord. My lord, the person was posted in Central Pay Bill Office in Shillong. Now, my lord, the action complaint of, my lord, arises outside the jurisdiction of this court. And, my lord, his application for, my lord, last leg choice posting was also rejected in Shillong, my lord. Since, my lord, there's a Meghalaya High Court, my lord. So, in my respectful submission, my lord, this honorable court will not have any jurisdiction to take up this matter. My lord. Only mere residents, he is a resident of Assam, he is a resident of Golaghat district. Mere residence doesn't amount to cause of action, doesn't amount to giving rise to cause of action, conferring jurisdiction.
Where are you posted now?
My lord, now I am
Shillong.
in Shillong, my lord.
You're
Central
posted
Pay,
in
yes,
Shillong.
Central Pay Bill Office, Shillong.
And the order is passed in the headquarters from
Yes, Shillong.
Assam Rifles.
Shillong. Both, my lord.
I think
My lord, I am from Assam, my lord. And
maybe.
the Assam Rifle is not only confined to Shillong and Meghalaya, my lord. So, my lord, my residence is Assam, my lord. So, my lord, I think, my lord, there shall not be any bar, jurisdictional bar, my lord. My friend is pointing out.
Yes, my lord.
It's not a.
No, you're challenging the orders passed by the headquarters
My lord.
Yes.
During your posting there. You're posted there.
Posted, my lord, at Shillong, my lord. Initial posting to put Shillong.
Because, my lord, mere residence in a certain place, my lord, doesn't give rise to cause of
Initially, I
action.
was posted at Dimapur, my lord. Paragraph 2 I have stated, my lord.
There was previously.
ARTC and yes.
Last
So,
posting,
my lord,
my lord,
it's an organization
Where
throughout the India, my lord. It's not a particular, it's not for a particular pit. Since I am hailing from Assam, my lord, I being an ordinary resident of Assam, permanent resident of Assam, why, my lord, this court cannot take up my grievance, my lord?
I'm relying on a decision of Apex Court, madam, reporting to 2021 Supreme Court. Okay. Lastly, kindly finish para 43 and 47. Though, madam, it relates to administrative tribunal, madam. Lastly, kindly see para 43 and 47 of the judgment, madam. AR 2021 Supreme Court 5281.
I thought.
5281.
Yeah, 2021.
paragraph
43 and 47, madam. And in this judgment, my lord, there are 44 also.
This is with regard to the interpretation
My
of the
lord,
rules.
my lord, yes,
Show us from the High Court rules.
my lord.
You show us from the High Court rules.
No, but my lord, your lordship has seen, my lord, the person was posted at Shillong. My lord, the order was passed at Shillong, order was received at Shillong, my lord. And after, my lord, he moved 4 applications, my lord, praying for, my lord, last like choice posting. Those applications were rejected in Shillong, my lord. Then how, my lord, this honorable court will have jurisdiction to take up this matter? Your lordship can see, my lord, here.
See, the jurisdiction in respect of the tribunal and the High Court is different.
Obviously, my lord, yes, that's why I
So you
pointed
give
out.
us an appropriate
Yes, my
judgment,
lord.
if you want to rely on. You give us an appropriate judgment.
So lordship may kindly come to Peta 44,
We have seen 43,
44, my lord.
44.
Yes. This is case of Utpal Kumar Basu is discussed here, my lord.
You place the judgment before us at 2.
Take it at 2, my lord.
Yes.
At 2.
2 p.m.
Yes.
2 p.m.
My lord.
Since he has raised an objection, we have to deal with it.
Yeah, 2, my lord.
Lordship, they were also statutory teacher. Now, Lordship, government has filed an affidavit. In the affidavit, they have stated as per scrutiny committee, they have, Lordship, already petitioner has been appointed in the substantive post and gave in regular scale of pay. Remain is regarding, Lordship, area pay. Lordship, we will file an affidavit, to the affidavit filed by the reply, Lordship. They have filed on 5/1/2024. Regarding
Same
only
thing.
remain only the area salary.
No, how can there be claim for arrear salary in view of these 3 lists, isn't it?
Yes, madam.
3 lists.
Yes, ma'am.
You fall on the list 1.
One list and according to that,
And you have accepted the appointment again.
we have accepted the amendment with objection.
Where is that? Where is that? Let us see.
That is why Lordship were to file an affidavit.
Oh.
They have stated in their Lordship, the teachers who has given salary up to 2007 has been given.
No,
regular-
but with objection will not help unless you put that order to challenge.
Lordship, that is why we have filed this on 5/1/2024. It has been received. We'll file an affidavit and we'll,
So on the affidavit, how do you challenge that order?
no, we'll take the instruction from client regarding filing affidavit or anything.
The request of Mr. S.K. Goswami matter be adjourned for 4 weeks.
Now they are getting regular scale.
That is what we are saying you. You have accepted, you have joined, you are getting regular stay, yet you want area pay pertaining to,
in
now it has become a different separate compartment
In fact, my lord, in the
and you have not put to challenge. Your area pay will come only when there is a finding that yes, your service continued from that day. The finding of the committee is that you were irregular.
No, not irregular. They said they have get salary up to 2007 has been regularized. We are getting salary up to 2012.
No, why? No. Why the committee was necessary? Because these posts were irregular. They were not properly advertised. Therefore, some people were appointed irregularly. And the criteria was that if you continue to receive salary to 2007, then you fall into the first category, isn't it?
Yes,
Subject
madam.
to
Yes,
correction.
madam.
Lordship is away.
So merely because you received to 2007 doesn't make you a regular employee.
No. We have been accommodated in a regular post by the government itself. Thereafter, they have
The whole purpose of the inquiry by the committee is in respect of those posts where people were appointed irregularly. That is the
Yes, madam. And in fact, the press
that is the
appointment.
whole purpose. You have been subjected is one aspect. You having been subjected, you have been selected and placed in category 1. You have accepted the appointment and you are getting your regular salary on one hand. Now you want to say that no, I want to press my petition for payment of early arrear salary. There is a hurdle, which is that order by which you are now appointed. That here you will have to challenge it to say that I am accepting this on objection. My claim is with effect from so and so date.
that is why we take the instruction.
In fact, in the press appointment order, there is a condition, my lord. They cannot claim the past service benefit.
Unless it is put to challenge and before the court, where is the scope for examination? Yes. No affidavit.
No affidavit. I was supposed to get some instructions, Your Lordship. We were supposed to get the instructions.
No instructions.
I have also only got some oral instructions just now, Your Lordship, that they are considering it from the CDPO. They're trying to get some documents from the CDPO. What's the salary that they are getting? What's the difference and what's the reason for that? They're trying to get some ascertain it from the CDPO, Your Lordship. Some instructions are awaited. They're saying that they will send it today, but that I cannot really guarantee that, Your Lordship. If Your Lordship can give it at least time till Friday, I'll try to get some instructions. Otherwise, orally, I've just talked to the person and telephonically, and he just said that they are consulting with the CDPO as to what's the reason why this has not been paid and what's going on, Your Lordship. They're trying to get. There are apparently 2 CDPOs involved in this case.
They means who?
Your Lordship, at the directorate level, Your Lordship. I just talked to the joint secretary who's attached with the directorate right now. He said that.
I know the CDPO is nobody to determine the parity of salary. my lord.
I agree. They're trying to understand what's the like missing figure, what's the difference in the pay and all. That is what they said, Your Lordship.
You are appointed as
Statistical, my lord. Assistant,
statistical assistant.
my lord, in the social welfare department.
Now you are claiming pay parity with whom?
With my juniors, my lord.
In the
Only
social
in-
welfare.
in the- Yes, my lord. In the select list, my lord, we were senior, my lord. Then, my lord, we were not appointed, my lord. We had to approach this honorable court, my lord. Then by direction, my lord, we were appointed. Then when we sought, my lord, parity, my lord, then a direction was given, my lord, to the commissioner to pass a speaking order. The commissioner passes a speaking order, my lord, and my lord, directs that the parity should be maintained, my lord. In the meanwhile, my lord, there is a set of another similarly situated candidates who had approached this honorable court, my lord. And a judgment was passed, my lord, in that respect, which I have given at Annexure 6, my lord. So I claim the same benefits, my lord, in view of that
Take us
judgment,
to
my
the
lord, which has been
take us
passed
to
by-
the finding of the commissioner.
my lord.
This number, possibly page 20 is the final paragraph, Your Lordship. Finding.
At page number 20, the final is, my lord, hence it is directed that the Director Social Welfare Assam appointing authority of statistical assistance will consider the case of the writ petitioners accommodating them for appointment in the post of SA in Sonitpur district after considering all aspects, reservation rules and other existing rules and regulations, as well as approval concurrence of finance department and other competent authority. The Director Social Welfare Assam will take immediate necessary steps accordingly. Thereafter, there is another order of the minor Directorate of Social Welfare. At page 22, my lord. In the second paragraph, in view of the above, subject to submission of medical fitness certificate and police verification report to the competent authority, Sri Chiranjeev Nath, son of Sri Mohendra Nath, village South Hajarapar, Tezpur, Sri Ranjan Jyoti Sharma, son of Sri Khagen Sharma, village Narayankati, Sonitpur, and Sri Tulumoni Sharma, care of Sri Sotindra Sharma, Sanmari, Tezpur, are hereby appointed as statistical assistant in the office of the Child Development Project Officer, Tezpur, so and so, so and so, so and so. Now, because
So
we
what
were
happened
appointed
after
out
that?
of the
After
same-
that, the pay increased or what?
No, my lord. It
Then?
remained as it is. But then, my lord, what happened is that in the same select list out of which we were appointed, my lord, those who were junior to us, my lord, they are getting now more pay and we are not.
That's what we are asking you.
My lord.
That prior to at the time when you were appointed,
My lord.
whatever the pay was,
My
by the time you joined, was there an enhancement in the pay?
That I'm not
How
sure.
they have been given the higher pay?
That is the question we are raising before this court, my lord.
No, you are raising, but how can the court answer unless there are materials?
The material your lordship finds in the judgment, my lord, which starts from page 25.
25.
Page 25. Shall I place that, my lord?
Yes.
Heard Mr. I. Rafiq, counsel for the petitioner, also heard Mr. J. Singh, counsel for the Social Welfare Department. As per the office note dated 15/11/2000.
This is a writ petition in which you are the parties.
I am not a party member.
Some other person.
Yes, similarly
Some
situated.
juniors.
Yes, ma'am.
pursuant to which they were appointed.
Yes, my lord.
Yes, please.
AD card has been returned back from the respondent number 4 and as per the court's order dated 15/6/2016. Services are deemed to be completed against the respondent number 5 to 8. However, despite the above, no one appears for respondent number 4 to 8. The petitioner's case in brief is that the petitioner took part in the selection process in pursuant to an advertisement made in the year 2005 for filling up of 12 vacant posts of statistical assistants under the Social Welfare Department in Hooghly district. The petitioner took part in the selection process held in the year 2006 and thereafter a merit list was issued by the state respondents wherein the petitioner whose roll number 1719 was placed at serial number 6 in the merit list. The petitioner's counsel submitted initially 6 persons were appointed in the year 2006 out of 12 vacant posts of statistical assistant. As the remaining 6 posts were not filled up by the state respondents, the respondents number 5 to 8 filed WPC number so and so, praying for a direction that the remaining 6 posts should be filled up on the basis of the merit list. The above 2 petitions were disposed of by a common order dated 8/6/2011.
No, where is the order of 4320?
4-3.
You come to page 21.
Yes, ma'am.
So finally, the direction of the court was to fill it up in consonance with the directions passed by the court in these 2 writ petitions.
Yes, madam.
Are these orders available here?
These orders are not available here, madam.
Then
And
what
these
does
were-
it say?
These were some other petitioners, madam. These are not, they were similarly situated because these, my lord, posts, actually what happens is, my lord, these posts were made to be appointed, my lord, from persons of the respective district. Now, in case of the petitioners, what happened is that they were, my lord, applicants from the Sonitpur district. And in Sonitpur, in respect to their posts, my lord, in their places in the merit list, somebody from outside was appointed for which they had come to the court. And the court says that no, you have to appoint it and as such, give priority to the merit list and on the basis of that position in the merit list, they were directed to be appointed. And accordingly that, which I have read, my lord, from page 20 to 23, my lord, it was done and they were, my lord, appointed, my lord.
Lordship, the order dated 20, your Lordship is seeking the order dated 2010-11. That order, your Lordship. Just now, your Lordship was saying. That order is there, otherwise, your Lordship.
Where?
And page number 15 and 16, your Lordship. 2010-11, your Lordship was possibly referring to that order. In pursuance of Honorable Guwahati High Court Order 2010-11.
No. This is not the case. This is WPC 35.
In this case, my lord, the petitioners were, my lord, parties. On the basis of this direction in this case, my lord, the commissioner was directed to pass a speaking order, which I had read out, my lord. And thereafter, the petitioner directed the Director of Social Welfare to pass an order, and appropriate orders were passed, my lord, which I had read out before, my lord.
No, but the question is, why is there a disparity in the pay? On what basis?
That, my lord, now they will be able to explain, my lord, now then they do not come up with an affidavit, my lord, after 6 long years have passed. And before this court also, my lord, they took, my lord, time.
You call for the records.
Lordship.
We issue rule here.
But
There's
then,
no
my
point in.
But issuing rule will again keep this matter perhaps, my lord, pending for long. Rather than that, my lord, let them have, my lord, 10 days or 12 days time or 15 days time, my lord, to produce a record. And on perusal thereof, my lord, it can be, my lord, disposed of, my lord.
We are also.
So therefore, to call for the records, we thought we'll issue rule. That's the. Or we give them one more opportunity. One final opportunity to get the instructions. Mr. G. Chaudhary, learned counsel for the petitioner, Mr. C.S. Hazarika, learned government advocate, submits that no affidavit has been filed as no instructions are forthcoming from the direct office of the respondents. Stop, he prays for further time. Stop. This court, it is seen that several orders have been issued since 2018, permitting the respondents to obtain their instructions. However, every time the matter is listed, prayer is made seeking an opportunity to file affidavit. and in spite of opportunities being granted, no affidavit has been filed. Purely for the interest of justice as a matter of last chance, the respondents are permitted an opportunity to furnish necessary instructions to the department counsel and obligor file their counter affidavit if so advised. No further opportunity will be granted. Matter will proceed on the basis of the pleadings available on record. List after 4 weeks.
Highly obliged.
Can it be on 23rd of February, my lord?
We said 4 weeks.
4
So
Can I
give
date
you a
be given,
date
my
after
lord, then?
4 weeks.
On 4th of March, my lord?
No, not 4th of March. We'll have it on 11th of March.
My lord.
11th.
I'm diplomat.
List on 11th of March.
My lord.
Obliged, your lordship.
In these matters, we have sought for some instructions earlier, lordship, from the petitioner's lordship, but then we have not received that.
What instructions?
Lordship may kindly peruse the order dated 30/11/2023. Lordship.
Hmm.
Therein, lordship, the department was required to quantify the amount that was sought to be recovered, lordship. And that instruction we wanted from our client also, lordship. So, lordship, that was not received, and they also have not produced that, lordship. So,
একজন করবি নাকি? ওই যে এটা।
30/11/2023.
Huh.
Therein, lordship, the second paragraph. In order to effectively decide the matter, the amount sought to be recovered by the department pursuant to the interim order dated 25/2019, issued by the Director of Higher Education in respect of the 3 advance increments issued to each of these petitioners will be specified and be placed on notice code by the next. Lordship, that was what was, lordship.
Yes, respondents.
Lordship.
Respondents.
Lordship, here in this matter, Lordship, last night the counsel for the petitioners sought for our consent to mention these matters, Lordship. That's why, Lordship, some records are there with K. Gogoi, Mr. K. Gogoi, so he has not got this records, Lordship, since our consent was taken last night. They were supposed to adjourn these matters, Lordship, in the morning, Lordship. That's why, Lordship, we have not got this.
Why the amounts were recovered, sought to be recovered?
Different in, on the case.
Yes, anything to do with their PhD?
Yes, well, when, if one candidate gets a PhD degree, at the entry
an
level, they
advance
get an advance increment.
Then their PhDs are not regular.
No. There was the increment was, my lord, given in last occasion, my lord, lordship takes up the matter, we explained it, my lord, that there was a confusion, why it was recovered. My lord. They are entitled to an increment, advance increment. That advance increment was, once the advance increment was granted, suppose 3 years increment was granted for at once. So next 3 years, they will not get the increments. Because 3 advance increments were given at once. That is in advance. So, but they were given the effect of advance increment later on. So, according to the government, there is an overdrawal. So that calculation was supposed to be shown to your lordship by the petitioner and also by the government. And on last occasion, that was the procedure as per the proceedings. Now, my lord, since my friend has taken time last night, so consent that they will adjourn the matter today. So perhaps Mr. Gogoi has not brought the records to the office, to the court.
That is true, lordship. I wanted the
The
instruction.
request of the learned counsel for the petitioners matter stands in for 4 weeks.
Highly obliged.
My lord, may record our presence.
Mr. D. Upamanyu for higher education, Mr. Chamoa for UGC, Mr. Talukdar for accountant general, Mr. Gugoi for finance. Yes.
Any date?
We can give you a date in July if you want. By this time, perhaps your instructions may be available.
There was some difficulty.
We have adjourned for 4 weeks. Let's see. There's no point fixing a date if you are not interested to do the matter.
We wanted that instructions.
How? When you have taken consent from the councils.
Because we didn't get that lot.
That's right. So therefore, we don't want to fix matters just to fill up the list. Yes.
My lord, last occasion I take time to file affidavit on episode in my records, the court's records also, but I have to file the reply because I cannot contact this. So some time may be given so that I can.
Mr. M.J. Borwa, learned counsel for the petitioner, prays for further time to file reply affidavit, rejoinder affidavit to the affidavit filed with the respondents. List after 4 weeks. None appears passed over. Mr. Talukdar,
For
for accountant general, MS Kemprai, learned counsel for the Karbi Anglo. Mr. Gogoi also?
Yes.
For finance. None appears for petition. None appears for the petitioner. Hey, you were there?
Happy, my lord.
Yes.
Well, last occasion, the name of the planning council finance was not shown, so there is an order. We have served the copy to them, my lord.
Yes, we have also communicated with the government, with the department. The instruction is awaited, madam.
Mr. D. Gogoi, learned standing counsel, prays
4
for
weeks may be given, madam, regarding pay period.
further time to obtain the instructions. To complete his instructions, Mr. P. Mohanpro, learned counsel, appears for the writ petitioner. List after 2 weeks,
4 weeks, madam.
4 weeks,
4 weeks, madam.
4 weeks.
Regarding
Mr.
pay
D. Upamanyu appears for the higher education. 4 weeks. Date. Date after 4 weeks, 11th March.
Masam.
Please, Lordship. On last occasion, Lordship, though it was submitted that on a similar issue, appeal is pending, which is yet to be decided by the division bench. Here, Lordship, the facts are slightly different. If I may place my case, Lordship. The issue is regarding non-payment of pension. They say that I was regularized after 1/2/2005. And they say that I am entitled for NPS. Now, that is where my contention is, Lordship. Even if I am entitled for NPS, but where I could not understand that how they could pay me my NPS.
You first get us the copy of the appeal, appeal order and all you show us. There's an order where it says appeal is pending where the issues raised in the present writ petition are covered.
No, that appeal is regarding the issues involving the writ petition which was dismissed. That appeal is pending.
That's right.
Yes.
Similar issues are raised here.
Only the issue is similar regarding the date of regularization, 1/2/2005. The issue which is being decided by the division bench is regarding the date of regularization. Here, I'm just placing slightly differently, Lordship.
All right.
Lordship, admittedly, the petitioner was appointed on 30/3/1990. Her post was regularized after 1/2/2005. If your Lordship produces page.
Lordship, may I pray?
Uh,
Lordship, may I pray for
accommodation only for today, your lordship. Because the respondent council has his maternal uncle is expired, your lordship, and he has to leave the court, your lordship.
Perhaps, if I may allow to submit, Lordship, his presence may not be required because what I'm trying to submit, Lordship, perhaps the original record may be required.
So let him come. We don't know.
Lordship,
We'll
Lordship may
pick it up
fix a
next
date.
week. Next
Yes,
week.
Lordship may fix a date. Lordship.
Next week. You'll come any date next week.
Lordship.
Matter be listed next week on a date to be fixed by the registry. As it is submitted by the learned council for the Dima Asau,
Yes, yes,
that the standing council is in bereavement. Matter be listed next week.
Well, sorry to trouble me, Dr. 28.
We have deferred it after 4 weeks.
Maybe little bit earlier because we are not getting. And I'll be filing an additional affidavit also. At 2 weeks, Miller.
Item 28.
28 Miller. Because I was in late. Because juniors are getting more skilled than me, my lord. Because allegation is this one, I could not join due to election duty. That is not my fault, my lord.
No, but now your adversaries have disappeared, na? So we had passed it over for the day.
Anyhow, my lord.
Mr. C. Borua appears for the petitioner.
Petitioner, 2 weeks maybe for filing additional affidavit.
He prays for 2
Because
weeks' time to file. Reply affidavit.
No, additional
Additional
affidavit.
affidavit.
For cases come up.
Additional affidavit.
2 weeks, my lord.
2 weeks.
Obliged. May I pay for date, my lord?
After 2 weeks, 28 February.
My lord.
That please, your lordship. Lord, this matter may kindly be taken at 3 p.m. I have informed learned council member Mr. Ramima. He is for respondent number 9.
No. You want?
At 3, my lord. Their prayer
3.
is to take at 3, their prayer, my lord. But
3
my
p.m.
prayer at 2, my lord.
Why at 3 p.m.?
My lord, at 2 another matter is fixed. Lord.
Oh. We'll take it up at 2. Please inform him to make arrangements.
Obliged.
Or we'll take it up at the end of the list. End of the part 1 list.
Possible.
It may remain at 2, my lord.
At 2. All right, at 2.
Here the affidavit is ready, my lord. I can file it by Monday, my lord. Item 30.
Submitted by Mr. B. Gogoi that the affidavit is ready to be filed. He prays for a day's time. Accordingly, matter be listed next week. None represents the writ petitioner. Yes.
Next, please, your
Next,
lordship.
engage senior counsel Abhisama side standing court number 1. Kindly timing, sir.
Yes,
34.
30.
Yes, my lord, 34. Item number 34.
Item 30, yes. 34.
Yes, my lord.
34. You are appearing for 34.
Okay. Okay, something wrong. 34.
No, passed over at 2. At 2 p.m. Yes.
34, lordship, yes. 34, lord. Yeah. Lordship, I'm sorry to say that, lordship, we were, the higher education department were directed to file an affidavit. Already we have filed, lordship, but due to some communication gap between me and my lordship, trained lordship, so we could not communicate with the department, lordship. So, lordship, I pray that at least 2 weeks time may be granted. Mr. D. Point appeared, lordship, earlier, but due to some communication.
We had already passed an order.
Yes, lordship.
So we'll have to pass some order.
Yes, lordship. Otherwise, also, lordship, that
What is your prayer here in the writ petition?
here, lordship, he is asking for the minimum wage and pay scale, lordship.
Otherwise, they were not appointed, neither they were engaged, nothing, no, nothing has been annexed, neither they were engaged against any post. Non-existent post, they were engaged by the hostel borderers, Lordship, and they have been paid by the hostel borderers. The question of retaining them or the question of paying them, everything has been done by hostel borderers, Lordship. No engagement letter, no appointment letter, nothing, Lordship.
Yes, absolutely right, Lordship. That
No,
is
but the
we have-
superintendent has issued.
That is no, that is the certificate, at page, Lordship, page 26 of the petition they tell. I'll show that instance, one instance.
Is the
Lordship.
superintendent.
Yes, superintendent, but the contents, Lordship, it says, the so-and-so of so-and-so is seen working is night secretary of hostel number 9, Jorhat Engineering College since 2013.
No, then why should the superintendent issue a letter like this?
Lordship,
If he is not, if he has not appointed,
not appointed, no
no,
one has
then why has he issued a certificate?
Lordship, the content said the pay, and is paid by the borderers of the hostel, Lordship.
Whatever it may be. then
Yes.
Let the borderers issue a certificate. Why the superintendent
Because,
is issuing?
because on sympathetic ground, they
What
approach.
sympathetic?
Lordship,
If
that-
he is not authorized to
Yeah.
issue a certificate, is not authorized.
He just,
Then kindly come to the next page.
Lordship, yes.
This is issued by the professor and head of
Yes,
department. civil
they
engineering.
are also saying, Lordship.
Then
Same, Lordship. In page 36 also, all are no
temporarily
engagement letter.
he's saying temporarily working on daily basis as laboratory assistant.
Yes, Lordship, there is no engagement letter, nothing.
Whatever,
No
but-
existent post, nothing, Lordship.
That is the whole question,
Yes,
that if these people are certified to be working, why is there no engagement letter?
Lordship.
If these people are certified
Lordship.
that they are working,
Yes, Lordship.
then why is there no engagement letter?
Lordship, the
How can
border-
you employ
they are-
somebody
they-
without issuing an engagement letter?
They have never employed, Lordship.
But why these certificates are issued?
Because
Have
of
you
the-
taken any action against these persons?
No, Lordship. No.
Eh?
They,
Are you saying that the certificate issued by the head and department of civil engineering has no value?
I'm not saying that.
What are you saying?
But they have not been engaged at
May
any
not be,
point of
but
time.
that is their claim, that
That
they
is
are
their-
working, but
Yes.
they're not paid any minimum wages, no engagement letters are issued.
Oh.
So the fact that they were working is certified by an office,
They have been
by,
working, yes, that is not denied.
Ah.
They have been working.
then if they're working, then you have to pay
Working
them.
means they have been hired by the borderers.
No,
That-
this is not what the certificate says. He's working as a laboratory assistant.
on daily wage basis. That is
Whatever, who has authorized the professor and head of department to engage daily wage laborers? Is he authorized to engage?
no,
Then
Lordship, no.
have you taken any action against the gentleman?
Not, Lordship. no.
Why? Why?
Even there is no post also. No existent post.
That is the
nothing.
whole
Lordship is correct.
question.
Lordship is correct.
You have made a system such a way that you cannot function without people, and you allow people to work without giving them any proper engagement letters. You are extracting their services. How is it possible that in a government organization, people are working unauthorizedly? And the statement which you are making, if you record it, is even a very, very sorry state of affairs, that the borders are engaging these people, paying them out of their own pocket.
Yes, Lordship. That is the certificate says that is the fact, Lordship.
If we are recording this, then we'll have to direct the authorities to make an inquiry into this and take necessary action.
I may be allowed, Lordship, 2 weeks. I'll communicate with the department, Lordship, because the last order we could not communicate, Lordship, because of our fault, Lordship.
No, but we had already given you time. Kindly see the last order.
Yes, Lordship, I have
Then-
seen it. I have seen it. It was not to my knowledge because my friend was there. He has communicated me lately, Lordship. Last time only I could get, Lordship. I'll do the needful.
No, but your lapses
Yes.
will have to be now borne by the department. You pay cost. You pay cost, we'll give you time, but you'll have to modify this order to allow you to file. There is a clear order.
Monday, Lordship, or Lordship, Tuesday we will file, Lordship. That may be.
Whatever you do, there is an order. If it is not filed, court will proceed to pass consequential orders in the matter.
Lordship.
Then you pay cost.
Lordship, 1 week time may be granted. Lordship,
No,
for
no,
this time, Lordship.
1 week you
Because
take,
of the communication gap between me and
whatever
my
it may
Lordship
be,
colleague,
you take 4 weeks, 6 weeks, we don't mind, but you pay cost.
It will be a little bit difficult, Lordship, on our part, Lordship.
You can't help it. Or we fix it for hearing, we don't give you opportunity to file.
Yes, Lordship, that may be done.
All right, matter be listed for admission hearing.
Yeah. have-
The respondents will have not filed their affidavit.
Lordship,
as
we
on
have
date.
filed affidavit. We have filed affidavit initially.
Huh?
Initially, we have filed affidavit. Our affidavit is there on record.
Okay.
Yes, Lordship. With this affidavit, we will proceed.
Very well. Then the matter be listed for admission hearing on 27th February.
Lordship.
Mr.
Yeah.
Popildar for
Higher education.
higher education, Mr. Gogoi for finance. Mr. Gogoi is willing to pay them basic minimum allowances. You are objecting.
No, but
Isn't
that
it?
some criteria is there otherwise. We'll have to examine the proposal.
He'll examine, he'll allow the payments. You are objecting, otherwise they'll get it. Yes, Mr. Gogoi?
No.
We'll hear on the
Yes.
next day.
Obliged, Lordship.
Mr. M. Yes.
May I please have the lordship? My lord, the matter relates to pensionary benefits, my lord. My lord, in fact, I have received the provisional pension and other benefits. Regular pension has not been paid. My lord, the stand of the department is that there are some, my lord, some nominee problem is there. It's my pension, my lord.
Who's for the accountant general?
Accountant general.
What instructions have you got? You see the last order, 12-1. Have you seen the order, last order of this court? Accountant general was permitted to obtain instructions in the matter.
May I please your lordship, can time may be granted for 2 weeks for instruction?
What is your prayer here?
My lord, my lord, provide me the full pension.
Pensionary benefits.
My lord. Now, my lord, they have paid me the provisional pension and other GPF and other, my lord, pensionary benefits.
From
Now,
which department?
my lord, Public Health Engineering Department, my lord.
Public Health.
My lord.
You have sent the papers.
Yes,
You've sent the papers.
yes, lordship, papers have been sent, only the final pension will have to be, that pay slip will have to be released by accountant general. That has not been done yet.
Okay. Heard Learned Counsel for Parties. Mr. I. Bodhakur, Learned Standing Counsel, PHE submits that the relevant papers have been furnished to the Accountant General's office, and upon receipt of the pay slip, the final pension will be processed. MS so-and-so Learned Counsel for the Accountant General prays for 2 weeks' time to complete her instructions in this matter. List after 2 weeks. 28th of February. Mr. A.R. Bhuya for the petitioner.
Firstly, as per order dated 30/11/2023, if you call for whether the petitioner is serving from 2013 or not, that instruction is called for.
There is another, what is the meaning of this instruction? We have not been able to follow.
Last part, my lord.
The entire instruction, they are referring to some other case, 4760.
No, Lordship, that order I have annexed, is the court order.
Earlier, my lord, he
Where the
approached
court
approached
directed
this
to
honorable
appoint
court.
him as compassionate appointment.
Page 25, my lord.
Yes, 25. After that order, Lordship, the director appointed me, Lordship, page number 26.
Without following the procedure, my lord.
No, Lordship.
Now, fact is that he was appointed by the department.
Yes.
But my lord, for compassionate appointment, there is a procedure, my lord. So it is in violation of that procedure, my lord.
What is that procedure?
But it has to be come from the DLC, my lord. Proposal has to be submitted before a district level committee. On recommendation of the district level committee, it will be placed before the state level committee.
So you forward these proposals. Why the proposal is not forwarded?
Lordship, may I submit?
Please. Yes, please.
Lordship, as per the appointment, Lordship, the post has approval of finance department at the initial stage, Lordship. Kindly see the first paragraph, last line. Thereafter, Lordship, what happened, Lordship? I am the grade 4 employee. After death of my father, Lordship, the director informed me to submit all the relevant paper, Lordship. After this court order, I have submitted and accordingly I have appointed because I am eligible for compassionate appointment also at that time. My father was died at that time, Lordship. Thereafter, what happened, Lordship? From 2013, they have processed some paper also for my salary, Lordship. Page number 29 and 30, kindly see,
No,
Lordship.
first tell us 4760 is filed by whom? By your father?
No.
Huh?
I have filed for compassionate appointment.
You have filed it.
Yes. But irregularity in the part of government, Lordship. How I am responsible for that, Lordship? I am a grade 4 employee, Lordship.
This order on page 26 is passed by the director.
Yes, madam.
That has not been recalled.
And as per this order, I am serving last 8 years, 10 years, Lordship.
This order has not been recalled.
Yes, madam. This has not, but facts remains, my lord. His appointment was without following the procedure. Because it's a compassionate appointment, my lord. And
But that is also passed by an officer.
it's a wrong order, my lord.
So you'll have to decide on this and pass an order on this, whatever you want to do. Tomorrow, assuming if you want to say that he's not authorized, you have extracted service out of him. Then it has the approval of the finance SIU.
Post has the approval, my lord.
Post, not the procedure.
It was
You are questioning the procedure.
No, my lord.
approval
Page
on 1/3/2008, my lord.
30.
30. It's dated 11th of December 2014.
Which was expired, my lord.
Second line of the, my lord, first para.
Hmm.
The post has the approval of finance SIU department, white so and so dated 1/3/2008. And the validity of the said finance SIU department expired on 31/7/2008.
Before his appointment, my lord.
Yes.
That's why, Lordship, ex post facto approval is seeking from last, that time, Lordship. From
You give
2000.
the approval now.
Yes.
His man is appointed.
Apparently, Lordship may see page 25 for a moment, madam. This is a part of the order passed by the Honorable Court earlier. Para 2 speaks about compassionate appointment, and the final direction is at last para. Having regard to the issue raised and the decision of this court as above, the petition is closed with the direction that the petitioner's case would be considered in terms of the guidelines laid down therein. No court.
No.
So Aishu Ranjan Das guideline, my lord.
But this order has not been recalled.
That of course, my lord, They will have to act upon.
It
way
has to
of,
be recalled
making
or
an
some order has to be passed. This was passed in 2013.
Yes, my lord.
11 years this man is working. You made him work and you're not paying him a salary.
They can correct it, Lordship, because I am working.
Ma'am,
they
kindly
can-
let
I
see
am
the order,
eligible,
first
Lordship.
part of the order, my lord.
This is
Which
not
order?
the fact that I am not eligible, Lordship.
Appointment order, my lord.
Ah,
It's been mentioned in compliance of the order of the Honorable High Court passed in so and so.
Yes.
Because that order, there is no direction to appoint him, my
The
lord.
fault of the officer.
we agree with anything, but you do not say this order is forged or interpolated. Page number 26.
This is a wrong order, my lord.
But wrong order, but passed by an officer. This wrong order has remained in the records of the government.
Yes, my lord.
You have not taken any steps to rectify this order or the consequences pursuant to this order.
As per my latest instruction, my lord, there is direction from the government to place the matter before a DLC, my lord. That has not been done till date.
So, but what is the point in placing it before DLC now?
Because it has to be routed through DLC, my lord.
All right.
But for my current salary, why they kept pending, Lordship? I am working, Lordship. I have right to.
Then how are you working for 11 years without salary?
Lordship, there are so many communication, Lordship. The office.
No, but
saying-
how are you surviving? That is what we are asking you.
Yes, Lordship. that is-
Do you have any other source of employment, earning,
Yes, Lordship.
business, cultivation?
No, Lordship. I am serving.
Then how are you
with a
serving
hardship.
when there is no salary
We
paid to
have
you?
some family members also.
Huh? On what
In
basis?
fact, Lordship, he has no idea about the case also, Lordship.
Oh, very nice.
They can rectify, Lordship. In the meantime, my salary may be released.
Hard learned counsel for the parties, this writ petition is filed with the petitioner. Praying for a direction to release his, praying for a direction to accord ex post facto approval of the appointment of the petitioner in the post of grade 4 Chokidar at Kachari Gaon Senior Madrasa, and to release the current as well as area salaries. So the petitioner was appointed. Petitioner's late father was working in which school?
Kasarigao Senior Madrasa.
Was as what?
At Chokidar, Lord.
Was working as a chokidar in Kacharigaon Senior Madrasa. Where is this school? Where is it located?
In Dhubri district.
Huh?
Dhubri.
In the district of Dhubri. Stop. Pursuant to the demise, expiry of the father of the petitioner while he was in service, petitioner approached the authorities for appointing him as chokidar, yeah, on compassionate ground. Stop. His application not being considered, he approached his court by filing WPC number 4760 of 2007. Stop. The coordinate bench of this court by order dated 12/9/2007 disposed of the writ petition with the following order. Extract page 25. Pursuant to the order passed, the petitioner was appointed by the order dated 11/6/2013 issued by the Director of Madrasa Education. Stop. The petitioner joined in his service on 12/6/2013 in terms of the order of his appointment. Stop. However, after the joining of the petitioner, the salary of the petitioner was not released. Stop. He represented before the authorities, and from the communications between the Director of Madrasa Education and the Commissioner and Secretary, Government of Assam Department of Education. It is seen that the post in which the petitioner was appointed received the finance within bracket SIU department's approval on 1/3/2008, and the validity of the same expired on 31/7/2008. Stop. The department has not thereafter the approval as required from the finance SIU department has not been obtained in respect of this post, and therefore the salary of the petitioner could not be received. It is the submission of the learned counsel for the petitioner that in spite of rendering dedicated service since his date of appointment, since his date of joining in the post of Chokidar in so-and-so madrasa school, the petitioner has not been granted his salary in spite of requests made before the authorities concerned. Para. The respondent number 1, Secretary to the Government of Assam, has filed an affidavit in opposition where there is an averment that the since the approval of the finance SIU department expired on 31/7/2008, as on date, there is no approval in the post in which the petitioner is working. And that apart, the process for appointment of the procedure prescribed for appointment on compassionate ground has not been followed while the order was issued by the director, secondary director madrasa, by order dated 11/6/2013. Stop. The Director of Secondary Education has brought it to the notice of the concerned Deputy Commissioner of the district, namely DC Dhubri, to consider the representation of the petitioner within the framework of the guidelines for appointment on compassionate ground. Stop. However, the same has not yet been carried out. Para. Learned counsels for the parties have been heard. The petitioner is working as Chokidar in so-and-so madrasa pursuant to his appointment dated 11/6/2013. Stop. This appointment was required to be done on compassionate ground as per the direction of, as per the order dated 12/9/2007 passed in WPC so-and-so. Stop. By the said order, there was no specific direction to appoint the petitioner. However, the writ petition was closed with a direction to the respondents to consider the case of the petitioner in terms of the guidelines laid down for compassionate appointment. Stop. Perusal of the pleadings available in court, available before this court, reveals that procedure prescribed by the guy for compassionate appointment is laid down in Achyut Ranjan Das in WPC 3875
Yes, ma'am.
of 2005, which was subsequently which was followed by the government, and the same guidelines were subsequently brought by way of an office memorandum. At present, the office memorandum dated 1/6/2015 is presently in force. Stop. The guidelines laid down by the judgment of this court in WPC 3875 of 2007 within bracket Achyut Ranjan Das and the subsequent office memorandums lay down a detailed procedure as to how the applications for the guidelines or for consideration of the writ petitioner is to be for appointment of writ petition for appointment of persons under compassionate appointment are required to be carried out. So from the pleadings available on record, it is clear that there was no specific direction by the coordinate bench by order dated 12/9/2007 in WPC 4760 of 2007 to appoint the petitioner on compassionate ground. The direction was for consideration of the case of the petitioner for appointment on compassionate ground. Nevertheless, by order dated 11/6/2013, the then director of Madrasa Education issued an order appointing the petitioner. Stop. This order does not reflect that the same was carried out pursuant to an exercise as per the procedure prescribed under the judgment laid down in the judgment of Achyut Ranjan Das Supra or the office memorandum which was prevalent at the relevant point in time. Stop. That apart from the interdepartmental communications, it is seen that the sanction of the what is it called? The sanction.
SIU approval, ma'am.
SIU approval of the finance department had also expired well prior to the petitioner being appointed. And as on date, the SIU approval is not available. Stop. It is also seen that the order of appointment by the petitioner, order of appointment issued to the petitioner dated 11/6/2013 issued by the Director Madrasa Education. Although the same is stated to be not as per the procedure prescribed, is still in force and has not been withdrawn or reviewed by the department. It is also seen that the petitioner is stated to be working in the state post of a chowkidar under so-and-so madrasa, and which averment made in the writ petition is not disputed by the respondent authorities. Under such circumstances, it is clear that although the appointment order dated 11/6/2013 was not issued as per the procedure prescribed, the fact remains that the petitioner was appointed pursuant to this order dated 11/6/2013, and he has been rendering his services since his date of joining on the state post on 12/6/2013. Stop. It is evident that the petitioner has rendered his services since his date of appointment and joining in the state post. Stop. Under such circumstances, notwithstanding the procedure not having been followed by issuance of the for while issuing the appointment order dated so and so, the petitioner was permitted to work and service was extracted from him by the department. And therefore, for the period he is rendered service, his entitlement to the salary and wages and other financial benefits cannot be withheld or denied. Stop. Under such circumstances, the respondent authorities will, namely the Director of Secondary Education, you write do you have that copy of memorandum?
Right now, I don't have.
You write the office memorandum 16/2015, which lays down the detailed procedure, was never followed. The office memorandum. Is there any requirement, is there any provision for finance approval under that office memorandum?
That will be, my lord, at the time when, my lord, they will finally recommend the petitioner, say in the present case. In that case, my lord, they will have to seek the SIA approval for the particular project. If selected, including the finance budget department approval for releasing the salary part.
Who is to recommend? SLC?
Yeah.
First DLC, then SLC.
Well, the OM is there, man.
As per the OM dated so and so, in terms of the OM dated so and so, as per the procedure prescribed are laid down on the clause 11 of the said OM, which contains as many as 10 principles. Stop. Perusal of the judgment of this court in Achyut Ranjan and read with the OM, which was prevalent at the relevant point in time, Earlier OM would be what, 2009?
2009, my lord.
2009 OM. It is seen that the procedure prescribed requires the matters to be first considered, forwarded by the administrative department to be placed before the district level committee, which is chaired by the deputy commissioner of the concerned district. Upon recommendation by the DLC, the matters are placed before the SLC, which is chaired by the chief secretary of the state. Stop. In the peculiar facts of this case, this procedure, for reasons best known to the education department, is it under education, madrasa?
Yes, yes, my lord.
It's education, secondary education department. The procedure was not followed while issuing the order of appointment dated 11/6/2013, pursuant to which the petitioner joined in his service with effect from 12/6/2013. Stop. As a sequel to the procedure prescribed not being followed, perhaps the SIU approval required from the finance department has not yet been issued before the in respect of the state post, and as a consequence thereof, the salary for the petitioner, which is found to be payable for the services rendered, has not been released till date. Under such peculiar circumstances, this court, under the powers conferred on this court under Article 226, issue a mandamus to the respondent department, namely the respondent number 2, Commissioner and Secretary. Sorry, respondent number 1, Commissioner and Secretary, Assam Education Secondary Department, to forward the relevant papers pertaining to the appointment and this service rendered by the petitioner to be placed before the Chief Secretary of the state. Stop. The Chief Secretary of the state, in his capacity as the chairperson of the SLC, will.
The procedure is to place before a DLC.
We are bypassing that procedure. Will pass necessary orders on the. We'll pass necessary orders as required under the office memorandum prevalent at the relevant point in time for compassionate appointments. Stop. This specific order is passed by the court in view of the fact that the petitioner was permitted to work by the order passed by the director of madrasa dated so and so, and that order as on date has not been recalled or reviewed, and the petitioner was made to work without payment of any salary. Stop. Upon the matter being placed before the Chief Secretary in his capacity as the chairperson of the SLC, the SLC will pass necessary orders directing, regularizing the approval of the petitioner appointment as a compassionate appointment with effect from the date of the order being passed, and the matter be brought to the notice of Finance Department for grant of necessary approval, post facto approval to the post in which the petitioner has been appointed. This entire exercise be completed within a period of 90 days from the date of receipt of a certified copy of this order. Writ petition is accordingly disposed of in terms of the above. Yes.
Salary part. Salary.
Salary part we have directed. You'll have to wait for 3 months. Pardon.
Oblige your lordship.
Mr. Khatuniar.
Yes,
Just 1 minute. The school is provincialized.
Yes, my lord. Earlier it was a madrasa, my lord. Now it is secondary school, my lord.
I will file to now. What happens to the management committee? They are not added as a party.
No, my lord. No. It was a senior madrasa, my lord. But subsequently it's converted
No,
to
but
a
the
senior sec-
order
Now it is
of
secondary
appointment.
department.
Huh?
Now it is secondary department.
No, but the earlier order of appointment shows that there was some recommendation by the managing committee.
managing committee, my lord.
No, that appointment lot is temporary lot. Before my regular appointment, I am serving voluntary lot.
All right, all right.
In fact, my lord, he never applied for under compulsory appointment.
That part is different.
On last line, this order shall not be treated as a precedence. This is issued in the peculiar facts and circumstances of the case before the court. Yes.
Oblige your lordship.
May I please, Lordship? Kindly pass over for the matter of time being, Lordship. TC Sutia election court number 20, Lordship.
Who?
TC Sutia, Lordship. He is appearing in this case, Lordship.
Okay, but already heard the matter, my lord. At 2, my lord.
At 2, Lordship.
Regarding age of
The
superannuation.
amicus.
Yes, my lord. That age of superannuation, my lord, of the petitioner, whether it will be 60 or 65.
All right.
Oblige.
Two.
Lordship, here, the matter come up after a long time, but anyway, we have got an instruction that from the social welfare department, the sanction has been given, your lordship. Your lordship, may I give the, just for your perusal, may I present the instruction? पैसा नहीं पूरा sanction को easier give it हाँ এই তো সব স্যাংশন অর্ডার হয়ে গেছে আর্লি সার্লি 24 আরো একটা একটা ইনস্ট্রাকশন তো আরো দিতে সেটা কথা 3F তো হয়ে যেতে পারে প্রভিশন হয়ে গেছে বাকি এরিয়া সেরিয়া কথা বলা দিছে এখানে স্যার এটা এডুকেশনাল জয়েনিং টাইম প্রভিশনাল আর আর্লি আর তার আরো একটা ইনস্ট্রাকশন আছে হেতু করে অ্যাটাচ দিতে হবে এটা না মানে এই দুটো একটা কথা
তাহলে ভালো না এটার ভিতরে now their leave has been sanctioned. Earned leave. Now it is what? Pending before personnel department.
No. Thereafter also, your lordship will see the other one, their personal department, because of the 3F, it was sent to 3F, but that 3F also has been given, your lordship now.
Where?
In the original document, this legal size paper, your lordship will find one of the documents, one of the enclosures.
So what remains to be done now? It is sent to the Accountant General's office.
Actually, your lordship, if your lordship look at the prayer, they are very fair. They have said that only with the direction maybe to send all the documents to the Accountant General, your lordship. If we go by that, then everything has been done, your lordship.
So you send it.
We have sent it, your lordship. That's
You have sent it.
these were sent, your lordship.
No. This is Have you sent it to the accountant general?
Yes, yes, your lordship.
It only says that it has been completed, but whether the papers have been forwarded or not.
Lordship could see the 18th one, again, the legal size one, I think there, everything is there.
No, it is says it has been completed. Records as sought for by so and so, so and so. Oh, have been sent. Okay. All right. So accountant general, who's appearing for accountant general?
Amount of policy.
Yes. Please get the instructions here to show it to her.
I'll give a copy, your lordship.
A copy may be given to me. I have not gone through it.
Share it with him if you want. Mr. I. Ahmed appears for the writ petitioner. Mr. C.S. Hazorika for the Social Welfare Department, who submits before this court on instructions received that all the queries raised by the Accountant General's office has been answered and met, and the papers have now been resubmitted before the Accountant General's office as far back as May 2023. MS Lala appearing for Accountant General's office will obtain up to their instructions in the matter. Let the matter be listed again after 2 weeks, enabling them to complete their instructions. You can go through the instructions. They have already forwarded it to Accountant Generals by answering all the queries. Now Accountant General is to update
A time frame may be given.
2 weeks.
2 weeks.
2 weeks.
A date may be fixed.
Matter be listed on 21st February. 21st. You take back the.
I'll share with both.
May I please, Lordship? Lordship, matter is regarding pension matter, this is. And on last occasion, Lordship, this honorable court directed the.
Yes,
Executive
Accountant
Engineer,
General.
PWD.
My lord.
PWD, Accountant General.
Submit the pension papers before the Accountant General. On last occasion.
Yes, so Accountant General, tell us.
My lord, the last occasion, directed to PWD, my lord, to seek further time, my lord, to complete his inspection on the, because my lord, we have returned.
My lord, just I'm placing the case, my lord. My lord will come to the last page of the writ petition, my lord. This is the case, my lord. Initially, the executive engineer has forwarded, my lord, the pension papers to Accountant General, my lord.
Then it was returned.
It was returned stating that whether concurrence of the finance department was there for regularization, my lord. My lord, I have written letter to all the authorities. I have received the instructions from the executive engineer, but from the government, it is still awaiting. There is a document, my lord, from executive engineer that he was regularized by the executive engineer. My lord, I would say this is beyond his jurisdiction. He could not have. Because without the concurrence of finance department, work charts employee cannot be, a government has to, my lord, regularize. That is why, again, I have written letter to the government, my lord, whether the concurrence of the, my lord, finance was sought, my lord, before regularizing. So they are looking into it, my lord. Just now I have spoken half an hour back, my lord. They said that they will verify the thing and shortly, my lord, they will send me the instruction, my lord. Otherwise, I have received from my lord.
1 minute. Yes. No concurrence.
So, my lord, that
Who will provide it? You will have to provide.
Exactly, my lord. So, my lord, government is looking into it, my lord. So, it's an old matter, my lord.
Does it require that time to look into it? You can get the instructions whether the concurrence is granted or not. Who is for the finance? Please find out whether the concurrence was granted. Do you have a copy of the petition?
Yes, I have the copy, but we'll.
Standing councils for PWD and finance are granted 2 weeks' time to complete their instructions as to the query raised by the accountant general as to whether concurrence of the government in the finance department was obtained before regularization of the petitioner. Let the matter be listed after 2 weeks.
Lordship, date may be fixed.
MS D. Angana appears for the writ petitioner. Matter be listed on 6th of March.
How less, Lord?
Mr. S.K. Medi for Accountant General.
How less?
May I please, your Lordship, in this case, there was a direction from this honorable court on 16/10/2023 to release the subsistence allowance of the petitioner within a month of 1 month, and that matter was fixed on 15/11/2023. And the thing is, the order was passed by this honorable court after hearing the parties appearing for the Lordship petitioner as well as the respondent. State respondents were Lordship duly represented on 16/10/2023. But subsequently, Lordship, it is willfully and deliberately violating this order of this honorable court, Lordship, that they have not even, Lordship, proceed for release the subsistence allowance to the petitioner.
Lordship, I pray for some time. We intend to file an interlocutory application for modification of that interim order, Lordship. Because Lordship, the non-engagement certificate and all the necessary documents have been submitted by the petitioner, Lordship, after he attaining the age of, in 2022, he attained the age of superannuation.
No, as per the
Lordship.
direction of this honorable court, Lordship, I have submitted, Lordship. There was a observation of this honorable.
And during,
And that was reflected in the affidavit filed by the state respondent, Lordship.
during the entire period of 28 years, Lordship, the petitioner never turned up claiming his subsistence allowance or anything,
When,
Lordship.
what is your prayer here in the writ petition?
Your Lordship will find at page number 13. Your Lordship will, prayer is starts from Lordship, page number 13. A writ in the nature of certain.
What is this, what is this order? 1995?
1995, your Lordship will find at page number 25. And in order itself reflected that I have been allowed to withdraw the subsistence allowance, but it is not released by this authority.
Lordship,
And particular person is Lordship, page number 26.
And you have approached this court in 23.
Lordship.
Why?
Lordship 23, but there was a circumstance, Lordship, that in the year 2002, and your Lordship will find.
You have
At
retired,
page
you have
number
superannuated now.
Lordship.
You are superannuated, retired.
Yes, Lordship. In the year 2002.
Have you,
Lordship.
did you receive any pension?
Nothing, Lordship. I have not even, Lordship, when I have been suspended, at that time, Lordship, I was met an accident when I was on the way to the Lordship office. I have put my applications to my family members, Lordship, before the concerned authority.
No, what is your prayer here? In the writ petition is
To
only for,
release the subsistence
only for subsistence allowance?
Only to the extent of.
Why?
Lordship, as well
Not
as
for
to
pension?
set aside and quash the Lordship suspension order, which is, in fact, Lordship, after 30 years also, Lordship, they have not even even initiated any disciplinary proceeding till today, Lordship.
Lordship,
Since last 28 years of Lordship service,
No,
they
but
have not initiated it.
You have not prayed for a pension or anything?
I have not paid. No, only.
Have you received pension?
Not yet paid, Lordship.
You don't want pension?
No, I want Lordship. For this Lordship, prior to that Lordship, everything was in the hands of the Lordship respondent authorities. Therefore, at the initial
Right,
stage,
heard learned counsel for the parties, Mr. P.N. Sharma, learned counsel for the respondents, please for further time.
Lordship.
Let the matter be listed after 3 weeks.
After 3 weeks.
Lordship, in the meantime, Lordship, this order may be
Nothing,
directed.
nothing.
Problem.
After 3 weeks.
Lordship, I may be allowed to file the amendment petition for Lordship pensioner benefit.
You file an application, we'll see.
May please, your Lordship. Lordship,
Yes.
here I seek for some further time to file my affidavit, Lordship. I have not received instruction yet, so.
Yes. Any objections?
No.
Matter stands adjourned for 4 weeks at the request of Mr. D. Upamanyu, Learned Standing Council, Higher Education. Stop. No objection is, the prayer made is not objected by the Learned Council for the petitioner. MS.
J. Simpo.
Appearing for the writ petitioner. Mr. S.K. Medi appears for Accountant General list.
Well, PPO and GPO already issued.
Issued.
Yes.
Then
Other part of the area salary
he submits that the PPO has already been issued and the petitioner is
and GPO.
and
GPO.
GPO have been issued and the petitioner
Area salary, lift salary, GIS is the Railway Department.
petitioner has been granted his pension, monthly pension. However, in respect of area salary,
Leave salary and GIS.
leave salary and
GIS.
GIS, the department is required to address these prayers. Let the matter be listed after 3 weeks.
Highly open.
In this case, my lord, the finance department has not filed the affidavit till now. And their affidavit is required because on their recommend in order.
Education and finance.
Yes. Finance is more important one. They have issued the impugn order.
Well, possible that sometime, my lord.
Mr. B. Gogoi, Learned Standing Council Finance, prays for
Right,
further time. Mr. B. Chakraborty, Learned, Purkaista Learned Council for the petitioner does not object. Matter be listed after 4 weeks.
Well, may I pray for a date planned after 4 weeks?
Let them file.
But in this case, though the orders have been issued, but the payment has not been made yet, my lord.
What orders?
Orders for GIS and leave salary, but the arrear salary has not been processed yet.
My lord, before that, my lord, sorry, my lord, this incident place in other cases, my lord. In that case, my lord, this 42, my lord. Sorry, my lord, this is my, wrongly it was, my lord, in that case, my lord. In this case, PPO and GPO, my lord. Sorry. Sorry.
You inform the council, we'll recall that order. Yeah, go to GPO, TPO to.
Yes, yes.
You inform the council.
Yes, yes.
Caller at 2.
Yes. At 2.
We have passed the order,
Yes,
we'll have to recall it.
Yes, yes.
একটু 2000 দিব earlier order strike out করে দিব
Madam, here GIS and leave salary has been sanctioned on 5th of January, madam. 2020.
Then rest.
Rest my lord, arrear salary, my lord. Accrued on the grant of benefit of MSCPS, my lord.
Have you filed your response? No.
No, madam, I have received an instruction regarding GIS and leave
You
salary.
filed your affidavit.
Yes, madam.
Respondent departments, elementary education and finance may file their respective affidavits. Councils are permitted further 4 weeks time to file the affidavit. Mr. This instruction you wanted to submit here.
Yeah, yeah.
Mr. S.K. Medi, Learned Council for the Accountant General submits that PPO and GPO
Yes.
have been issued. And the petitioner is
The leave
likely
salary,
to get the salary,
leave
get
salary,
the pension.
my lord, leave-
However, in respect of the other prayers regarding leave salary and arrear salary,
leave salary and GIS have been sanctioned but not disbursed yet.
in respect of the other prayers, the affidavits, be filed by the petition, by the respective respondents in the matter. List after 3 weeks.
Obliged, Lordship.
2 baje.
Maybe not. So this is the judgment, my lord. 1994 4 SCC 711, my lord.
Could have handed over.
Paragraph
Given a copy.
11, 12, and 14.
Give us a-
994 4 SCC 711.
Yes.
এইটা তো আপনার ওই পর্যবেক্ষণ বোর্ডে হয়।
Have you seen the judgment, Mr.?
My lord, I have seen this one, my lord.
No, this judgment, football.
That judgment I have not seen, my lord.
You go through it.
Lordship, may.
মানে another judgment,
On
my lord.
Friday, my lord, I will come prepared, my lord.
Friday.
Friday.
Obliged, my lord.
On Friday, at the request of an accountant. Mr.
Development.
Yes, for
Obliged.
the response.
Let go. Disputed the first wife, second wife, my lord. And your lordship, now they have taken the plea that they have divorced, my lord. And
Who has taken the plea? Husband.
my lord,
Who has taken the plea? Who has taken the plea of divorce?
that respondent number 9. In fact, I am, my lord, your lord, that is the order, last time, my lord, that your lordship also dealt with the matter last time also, my lord. And your
Mr. Mahmood, we were informed by your colleague that you are not available, you will be available at 3, but we can see you are here.
No, actually, in court number 3, another matter is fixed at
Oh.
2. But there
Then
are
the
some other
normal
matters.
prayer would be to take up the matter at the end of the list or on some other date. But
No,
your
now-
prayer
now I
made
told
on your
Lordship-
behalf was at 3 o'clock.
Well, actually, I told like this, because another matter is fixed on at 2 p.m. at court number 3. So there that is the senior bench and division bench. So however, now that court is taking some time for other matter, so Lordship may take up the matter if desires.
You are the first wife.
Yes, my lord, first, your lordship will find first wife, husband, he was a, my lord, grade 4 employee in a school, my lord. And retired on 36/16.
You have not been granted salary. I'm sorry, pension.
Pension. She is now, the respondent 9 is now taking.
Where is that order, impugned order?
That is not the order, subsequently it was given, my lord.
Where is that?
Because there is no stay order, my lord, in that case.
Where is that order?
Yeah, no, that order, my lord, last time the government, they have stated they are giving, my lord. The other side, my. You are getting pension now.
Yes, I am.
That is what.
She is the nominee.
They said she was made nominee, my lord. But even in the death certificate also, my name was there as a first wife, my.
No, who is Amina Khatun?
Amina, the respondent number 9.
So she was the nominee.
She is the nominee. That's all.
Uh,
Now her marriage took place between during the subsistence of the first marriage. That is also one violation of Rule 24.
What basis are you making these statements? That the marriage took place during the subsistence? Was there any
That is admittedly, my lord. The second marriage was taken on 91/92.
any application filed for maintenance?
Yes, it is. Your lordship will find page number, maintenance. Page 56, maintenance. Order is there, your lordship will maintain. The petition, my lord, I'll give you my lordship order. Page 50, page 21.
Huh?
Yes, page 20. This honorable court order.
Is page?
Page 21, annexer 1.
51.
This order is murdered 19/3/19. Husband, that the late, my husband filed case against me that is the order challenging that order by the court below. And ultimately, your loss will find. Here also they did not say anything about divorce, my lord. Nothing was stated. Respondent wife, all along it is stated, my lord, also I have heard, paragraph 8, my lord, page 23. I have heard the submission of the land council for both the parties. It is to be noted that the petitioner here admitted in his evidence.
No,
that
from
his
this order, is the date of marriage available?
date of marriage, my lord, of course, that is admitted, my lord, but for our record, my lord, as far we have stated, my lord, marriage took place in 1976, my lord, first marriage. 1976.
In this order,
Uh,
page number 21.
no, page number 21, of course, date is, my lord, it is not there. Maintenance petition to us. Date of marriage to us. Okay, date of marriage to us. Date of marriage.
Date of marriage.
We have stated paragraph 2, my lord.
No, mayor's statement will not do.
Yes, but that is admitted, my lord. Only question
No, no, admission is with regard to marriage.
marriage.
Now, in order to stake your claim as a first wife, you have to show that you were married earlier.
That is their case also, my lord.
Where?
They are saying, my lord, since they say they have given nominee to me, their response your worship will find. They filed the response also.
Yes.
That is not denied, but that is not in dispute at all.
Where is that?
Yes. Just page 28, you look at his death certificate. Page 28. Here also my name is number 1.
Who is Amina? Amina is
Amina is the
the
respondent,
respondent.
second wife.
Uh,
Page 28, madam. That is the best evidence part. Documentary evidence. Page 28. Magdina Khatun number 1, Almia Khatun number 7. And this is your lawsuit dated, issued 21/9/21. It was issued. And the date is dated 8/9/21.
What about page 46?
Page 40. Yes, page 46, my lord. In place of the following village elderly person. It is a permission, my lord, giving that here.
By whom?
In favor of?
By you.
Yes. That is, my lord. May take permission, that is not there.
Huh?
They may take my permission, I may allow that. That is, yes, but your lordship husband, I am the wife of the person.
No, if
He wanted to marry second time. He forced me to give permission, accordingly it was given. It is, I am not denying this also. Permission. But whether this will give my lord this forfeit my right or not. He cannot marry second time as per rule, my rule 23.
he was employed as a
grade 4 in a school, man. Official.
what does the rule say? 143
140 your lost kindly see the data.
pension. Amendment class.
143 your lordship will find sub rule minus 2 note 1. Extra copy of the government. This one is the This is 45 days, my lord, court has judgment to the Januha baby.
So you are claiming to be the eldest surviving widow?
Yeah, yes, I'm not claiming, it is a fact also. It is admitted. And your, yes. And your lordship, that is Januha baby case, my lord, your lordship is paragraph. That is also there. It is 45. Yeah. Paragraph 1920. That's just small paragraph.
Eldest of the surviving widow?
Yes.
Okay, yes.
May I have the lordship? My lord, first your lordship has rightly pointed out page 46. Well, now the petitioner has willingly, in presence of so many persons. It is not one. There are signature of 8 persons, my lord. She said that
yes, yes,
she has no objection if I get married with another lady. So that was in writing in presence of 8 villagers.
No, whatever. She has given permission, marriage is taken place. The question is whether she still is the eldest surviving widow.
No, my lord. That, for that, my lord, I invite your lordship, kindly come to page 52.
52.
Yes.
All right.
Yes, cross, bottom. The opposite party divorced me before filing of the case at Gwalpara. So she has admitted.
No,
I
divorced,
filed-
how?
Whether?
Divorced by proceeding, civil proceeding.
No, by written,
Talaknama.
by Talaknama.
Where is that?
That Talaknama we have annexed, my lord, that is page 48.
48. Not registered.
Not registered.
Then-
Yes, it should have been registered,
Ah.
but this has come newly in the field. But apart from that, my lord, though it is not registered as per the Muslim Marriage and Kaji Act or Muslim Shariat Act 1939, but it has got otherwise value because that was duly exhibited. That was duly exhibited. Let me show that exhibition.
Was there any, there was an order of maintenance passed, isn't it?
Yes, yes. No,
And
here,
then-
my lord, kindly come to page 52 bottom.
But this maintenance was not interfered with.
Maintenance part that cannot be now in existence because husband has died. Now, question is this,
No,
kindly
what-
see page 53. Well,
No, no,
next.
no. The query what I want to make is the court of the magistrate, SDJM, was it? Which order? Which court passed the
CJM, Gwalpara.
CJM? CJM, while passing that order, when was the order passed?
Maintenance order.
19 my lord, High Court, page 21. Order part 177.
1717. And this Talaknama?
97.
97.
97.
But there is a reference of some CJM court number here, page number 48.
Case number?
48. That will be annexure B of the affidavit filed by respondent 9. Annexure B.
Annexure B, Exhibit 2. In that maintenance case, I think.
Yes.
Exhibit in that maintenance case.
Now, where is the order of the CJM?
page two, oh, whatever the CGM is not High Court's order.
The High Court is there.
Right.
There is no order of the CJM.
Yeah, only it is say the 1717, madam, this only.
My lord, one another aspect of the case is this. Before 2010, my lord, registration was not compulsory. So that is the thing. Another thing, my lord, kindly come to page 52. Lordship would see, this is duly exhibited in presence of the parties. Page 52, operative portion, page 53. Page 53, kindly see, exhibit core A1, exhibit core 1, page 53. Exhibit core 1 is my signature, the signature of that lady. Signature was taken in blank paper. Is it? Now, it is not true that I have taken talak forcefully from the opposite party. It is not true that since I am a divorced wife, so I will not have any right of maintenance. Now, my submission is this. If she says that it was taken forcefully, whether she filed any criminal case against me, that was not done.
Which is why we wanted to see the CJM's order. Is it there? How has the CJM dealt with this exhibit?
Yes, that is, of course, another question. But thing
How
is,
is
she
it
has
another?
admitted. She has admitted this talakrama. Now, as per provisions of section 61, when it is exhibited, that is the first part is proved that this document is genuine. As per section 67 of the Evidence Act, contents are also proved. Because she has said that this exhibit 1 is the exhibit.
We have in the copy.
Exhibit core 1 is the talakrama. Now, this is by through secondary evidence, it is exhibited and it is acceptable as per provision of section 61 and 67 of Evidence Act. So, my lord, here my submission is this: as there is divorce and as there is a written consent, she filed no case. She says by force talak was taken. There she filed no case and it is duly exhibited. Whether it is genuine or not, this court perhaps in this jurisdiction cannot prove the genuineness of this document. So it is the better the party may go to civil. They say I am the first wife. We say you were the first wife, not the existing first wife. Existing wife is only one, that is the respondent number 9. So here a law question is involved here, madam. Question of law is involved here. Let her prove that she is still existing wife.
That is what we wanted to find out from the CJM's order. Where is that?
Magistrate order.
The one granting you maintenance?
Yes.
Was this talaknama was an exhibit before that court?
Yes. No, talaknama what by the yellow candidates cross the barnacular function, madam. You will see, madam. She has not admitted talaknama, madam. Your kindly see page, just I take your lordship, page 50, 52, 52, Annex C, madam. No,
yes.
not in
it is Harris.
Barnacular, madam, barnacular.
Yes.
Yes, barnacular means no.
Barnacular, my just say, Annex C of page 50, 153, line, page 2, take a minute. Yes. The Lord barnacular one, madam.
Yes, please read.
Yes. Page 2 in the internal page, your Lord. Your Lord, after 749, my Lord, তার সমামান পিছতে মোক পুনৰ মাৰপিট অত্যাচাৰ কৰে ও তালাকনামা দি ঘৰৰ পৰা উলিয়াই দিয়ে তালাকনামা দি আইনমতো দিয়া নাই দেন ইয়ল ফাইন লাষ্ট পাৰ্ট 1 paragraph last line, my Lord, মই অপপক্ষক তালাকৰ স্ত্ৰী বুলি মানি লোৱা নাই page 2 bottom last part 1, my Lord. Last part 1 line.
Kindly say the jera.
মই আপোনাৰ পক্ষক এইটো জেগা দেন মোক অপপক্ষই গোৱালপাৰা পেচ কৰাৰ কাৰণে তালাক দিছে দুবৰিত মই এইটো পিছত না কাগজে মোক চহী লৈছিল সত্য নহয় যে মই জোৰ কৰি অপপক্ষৰ পৰা তালাক লৈছিলো সত্য নহয় যে মই তালাকি স্ত্ৰী কৰি গৰাকী হকদাৰ নহওঁ মোৰ ল'ৰাটো স্বয়ংচ সত্য নহয় যে মই নাম লৈ মই নিজে অপপক্ষ ঘৰৰ পৰা গুচি গৈছো।
My lord, it is clear that she
that
said
was
that
in
before
2000.
before filing this case, he has divorced me. She has admitted. Now, force or not, that is, my lord, question to be determined by the court. But she has filed no case. And nominee has been made in my favor. It is also a point that she is not my wife. She has not challenged the nominee. So how she can claim nomination paper? She must challenge that nomination cannot be made in her favor because I am the first existing and surviving wife. So there are so many lacunas in this case. Madam. A thorough hearing may be, I think, necessary. So here are the questions. This before 2010 registration was not
Yes,
necessary.
Mr. Chaudhary.
My lord, she is getting pension. I am having still nothing, no other way.
You are having because you are not the wife as per the pleadings
No,
available
no,
here.
that's simply by saying not one. You also can listen talak now. Is it a talak now?
We don't know.
No, your lordship, it is a writ judicial. Your
No,
lordship.
no, that is why we want to see the order of CJM, how it has been dealt
No,
with.
CJM, I am having the order, my lord.
So what does it
I
say?
got the order, my lord. Your lordship. I got the order. That is maintenance proceeding, my lord. Their court did not agree that because that question of divorce I do not find, my lord, but it was accepted that she is the wife. Being treating her as second, as first wife, maintenance.
They show us the procedure that how talak is to be granted and what is the
We'll bring on
procedure.
record that order, my lord.
Huh?
We'll bring on record that order. We'll bring on record.
You want
Order
to
of the
bring on
CJM.
record.
That will be better, my lord.
All right. Mr. H.R.A. Chaudhary, learned counsel for the petitioner,
Next, anytime next.
submits that an additional affidavit is required to be filed to bring on record. What order you want to bring?
Order.
Order of the CJM,
CJM,
dated so and so.
dated 1/7. One
1/7/2017,
was
passed
passed
in
in
MCR case
MC
number
case number
239 of
239/15.
2015. And other documents in support of his contentions. Matter stands adjourned at his request. Mr. M.E. Mahmood appears for the respondent. Anyone for the government? Mr. Khatonier for Education Department, Mr. Sutia for what? Pension? Mr. Solia for Treasury Officer. Accountant General, who's appearing? And Deputy Commissioner, Mr. Sutia. List after 2 weeks. After 2 weeks. yes.
Obliged. Well, a date of your.
Date
Yes, madam. Next.
28th February.
Obliged.
Yes, Lordship, letter relating to suspension, Lordship.
Review?
No review, Lordship.
Any review?
No, my lord.
No review.
No.
All right then. We have passed orders earlier,
Lordship.
heard, disposed. Suspension. Petitioner is directed to be reinstated in view of the fact that the review as required under law has not been done within a period of 3 months. Any subsistence allowance required to be paid to the petitioner during this period of time shall also be released. Disposed.
Obliged, Lordship.
Itu hai.
Wait, please, my lord. My lord, petitioner was appointed as secondary discharge and after retirement, my lord, pension was not given, my lord. My lord, there is a cover judgment, my lord.
No, let them. Yes, what do you say?
No, Lordship, no instruction.
No what?
No, instruction is not yet received, Lordship.
Instruction not received, you see the judgment whether it is covered or not.
Lordship, let them verify, Lordship, if they are entitled, Lordship.
You verify and
Because-
tell us.
Yes,
Why
please.
should we direct? Give it to him. Give it to him.
Lordship, here,
You verify and tell us.
Lordship, here, one of the prayer of the petitioner is for salary also, area salary from 2012.
Ah,
And the area salary 2012, Lordship, those irregular teachers, they were also not paid area salary. So perhaps we need to file our affidavit otherwise.
You go through the judgment and apprise the court.
Lordship, I have seen the judgment.
Mr. P. N. Sharma will peruse the judgment placed by the petitioner and apprise the court whether the matter stands covered by the issues raised in the matter stands covered by the judgment raised passed in WPC 6403 of 2023, Purnima Hore and others. Matter stands deferred to be listed again next week. Mr. Rava for Accountant General. Next week.
Wait, your lordship.
Affidavit is filed.
Affidavit file, na? Affidavit file. In this case, well, what I find about disproportionate only thing. This person, my lord, he is a constable. He was posted in Naka duty. Allegation is that, my lord, without checking, he got them past the gate. And after 40 kilometers of distance from that particular place, 80 kilometers, these trucks were intercepted by. So my case is, my lord, it was empty truck. They have passed over. Thereafter, my lord, something loaded there and it was intercepted in far away. My lord. Your lordship will find from the show cause, my lord, first show cause, page 19.
You're challenging what? The order of
That is page, my lord, 44. Dismissal from service.
dismissal from service. So we'll keep it for hearing then.
Only, my lord, yes, but is there, my lord, but I think it will not take much time. Any other day also, my lord, it appears.
You are challenging the order of dismissal,
That's right. my lord.
including the inquiry proceeding.
The my short point, I am only now precisely confined to the disproportionate punishment. my lord.
No,
Besides from that-
disproportionate will also require examination of the record.
That's true, my lord. For that, my lord, it may come for admission, my lord, or my lord, your lordship.
Why admission?
Once you go for hearing, my lord, it will.
If
this
it goes
person
for
is out.
hearing, it will have to be heard.
No, hard with your lordship.
A matter which requires extensive hearing is to be
Everything,
heard.
even after order call, it is hard also. Admission also hard, my lord. I think, my lord, it is not a big matter, my lord. It does not require much of time, my lord. Any day, my lord, subject to your lordship's convenience.
On 5th of March, the respondents are
They have filed the
directed to keep the relevant records pertaining to the inquiry and orders passed by the disciplinary authority and the appellate authority, which are impugned in the present writ petition, to be kept ready for perusal of the court if the need arises. Mr. H.R. Chaudhary, Senior Counsel, assisted by Mr. H.M.R. Chaudhary, appears for the petitioner. List on 5th March.
Well, if there is an interim order, I was asked to vacate the quarter, my lord. I have no other way to go, my lord.
There is no interim order here.
In IA, one IA was filed.
IA has an
IA posted it twice in.
Where is the notice? Where is the notice for
Yes.
vacation of this quarter?
IA, it is page my dot 16, page 16. Oh, where is it?
The interim order passed in IA 3543 of 2023 will also continue till the next date fixed. Let the matter be IA along with the writ petition be listed on 5th March.
Public.
Hey, leave a pen with your problem.
Right? It is your lordship.
Yes.
My lord, the petitioner here, assistant professor in the College of Veterinary Science. Suddenly he was summoned to appear before a committee without giving him any particulars. He appeared there and within a day, some report was submitted before the VC and VC constituted board.
No, the last order is where we had issued notice and in case his subsistence allowance was not released,
Yes.
he was permitted to be released.
Partly it has been paid, but thereafter again they have stopped it.
Now, what about the respondents?
Lordship, Agriculture University is more competent authority to.
Who
authorize the
represents, who represents,
SC Agriculture is there, like SC Agriculture University is there, Lordship.
who is the SC? G. Bora.
Lordship, I'm for the Agriculture Department.
Okay, okay.
University is different, Lordship.
Where is the council for the university? Did you? SC, huh? Huh? No, SC, Assam Agriculture, AAU. Yes.
Lordship, I kindly come to page 12. At para 12, Lordship will file the impugn order because perfunctorily they constituted a body and inquired into the matter without giving me any opportunity of making defense. Lordship. No particulars were furnished to me, no witnesses were examined. That way, they have concluded. And
What orders were passed finally?
at paragraph 12,
Para 12.
it is a long order, Lordship. They have included everything there.
No, have you enclosed this order?
Page 12, Lordship.
Page 12, is this order enclosed?
Yes, I have
Annexure 7.
Annexure 7, Lordship. Long order.
Enquiry report furnished.
Lordship.
Enquiry report.
No, nothing was furnished, Lordship. A report was given, but that contained nothing, Lordship.
No, you have been given a copy of the report.
Yes, Lordship.
Is it enclosed here?
At page 23, Lordship will find the report.
23. There are serious allegations against you.
Lordship.
Allegations are very serious against you.
No, serious, but Lordship, if your Lordship look at page 37 onwards, they have submitted some papers where no name is disclosed, nothing was given to me. Allegations are apparently serious, but no opportunity was given to me to refute the same.
This is an inquiry under what? Where is the show cause notice?
Inquiry under Rule 7. And if your Lordship comes to page 32, Annex 3, there is
From the allegations against you, it should have been an inquiry under the Sexual Harassment Prevention of Sexual Harassment Act.
that is no permanent body in the office.
Oh,
They should have constituted some body for this purpose only. Everything was done in a hurried manner, and if, at page 32, Lordship will find the order.
yes, Mr. Sutia. The standing council is absent, so we are requesting you to obtain the instructions from the university with regard to the allegations made. Jorat, Assam Agricultural University. And regarding the allegations made here, there is no standing council, no affidavit.
Inquiry committee.
Please furnish one extra copy to Mr. Sutia.
Yes.
You can furnish, you request your junior, one extra copy of the writ petition so that he can obtain the required instructions. Third, Mr. C. Chaudhary, learned senior counsel, because we'll have to call for the records.
Yes.
Senior counsel assisted by MS Das, MS J.S. Das, learned counsel for the petitioner. MS Bora,
Lordship,
appears for respondent number
1.
1. It is submitted at the bar that there is a standing counsel for the Assam Agriculture University. However, the current counsel not being present, a request is made by the court to Mr. T.C. Sutial, an additional senior government advocate, to obtain the required instructions from the Agriculture University in response to the allegations made in the writ petition. Extra copy of the writ petition may be served by the council to the senior government advocate. Let the matter be listed after 2 weeks.
Lordship, a direction may can be issued for release of the substance along. We do they have
any subsistence allowance, you are suspended initially. You were suspended. Any subsistence allowance, if not released, be released to the petitioner. Yes.
I'm appearing for the Agriculture University, but the cause is shown that Agriculture Department.
On the last occasion, we had reported the name of a council.
Yes, Your Lordship. In the now just in the file item here is Agriculture University, Your Lordship.
Don't leave everything to the court and the registry. The councils were there, orders were passed, dates were fixed in the presence of councils. Who is MS G. Bora?
Lordship, I am G. Bora.
You are G. Bora.
Lordship. I'm for Agriculture Department, Lordship, respondent number 1 on.
Okay. Give your names to the court master.
Yes, Lord.
Extra copies be furnished to the standing council. Mr. Chutia, you are relieved.
Yes.
No, Agriculture Department.
Yes.
Departmental proceeding and criminal proceeding were initiated the same facts, and that has been continued now. The departmental proceedings should be stayed as per Paul Anthony's case and subsequent judgment passed by the Honorable Court recently. Lordship, my prayer is, Lordship, suspension order also not reviewed within 90 days. And on last occasion, Lordship has recorded that interim order will be considered today. Lordship.
Yes. Any instructions?
My lord, we have not received any instruction, my lord. So far, the Paul Anthony is, my lord, overruled. And after the same fact of, well, same evidence, my lord, departmental proceeding and criminal proceeding can be parallelly drawn, my lord.
No, it can be drawn, but on the same facts.
Same place.
Yes, same facts, my lord.
Hmm.
Yes, my lord, I have received some, my lord.
2023 10 SEC 675. That is a recent judgment by this Honorable Supreme Court by Honorable Justice Hishikesh Roy and Sanjoy Kyle.
The judgments are rendered by courts,
Lordship.
not by the judges. So it is sufficient if you refer to the judgment of a court.
Lordship.
What is the citation?
Citation is 2023 10 SEC 675, where Paul Anthony has been discussed and other three judgment has been discussed.
Page number
675.
675.
Not indefinite. The Supreme Court has said it should be straight for time being. 2023 10 SEC 675.
My lord, I have not gone through, of course, this
That is the
judgment.
recent judgment.
But the 2022 2 GLT, Gulab Sharma case also, my lord, is here. In continuation of parallel cabinet trial and departmental proceeding, common witnesses and evidence, common in both proceedings are common, pertaining to same incidents, held no bar to parallel and concurrent criminal proceeding. And another case is also, my lord, 2006, my lord, Kendriya Vidyalaya Sangthan and Srinivas. Supreme Court has, after discussion of the Captain M. Paul Anthony and B.K. Meena, laid down that the advisability, desirability, or propriety with regard to department proceeding has to be determined in each case, taking into consideration of facts and circumstances. Therefore, circumstances of the case. Therefore, Supreme Court says that the view that departmental proceeding criminal trial could not be proceeded simultaneously is a erroneous view and contrary to established principle of law to that effect. That's why they said it is a ballot erroneous view taken in there from Anthony. And another case also, my lord, 2014 3 SCC, my lord, Stanzem Toyastem India Private Limited and Greece. Supreme Court says that even if the charges are similar, and in the criminal case, the charge is of grave in nature involving complicated question of law and facts, there should not be any blanket stay order on the departmental proceeding, and outer limit of 1 year has to be included, where such a interim order of stay would be automatically vacated. So by this order, man also
That is my submission. Say 1 year it should be stayed. At least for 1 year. That is the Supreme Court judgment.
That is specifically
and Supreme Court has categorically stated that nature of proceeding wholly separate and distinct, equitable criminal case, that lordship they have stated the position of law is that stay of the letter.
Kindly read the paragraphs. Yes.
Para
Yes.
40 lordship.
No, before that.
Before that, para 22 lordship.
Ah.
As evident from the judicial pronouncement referred above, it may be desirable or in certain circumstances advisable for disciplinary proceeding to be stayed when criminal proceedings are ongoing. However, stay is not matter of course and is only in given after consideration of all factors for and against. Keeping view of the Neelam Nath case, following essential may be culled out. For the operation of clause 4, at least 1 year or two have been passed since attempt to get the delinquent employee to be prosecuted. If any case passes of such time, no prosecution is initiated, then departmental proceeding may be according with the procedure for disciplinary action. If the prosecution commences later on at point of time to the disciplinary proceeding, later shall be stayed, but no indefinitely. Such proceedings are to be stayed only for a reasonable period of time, which is a matter of determination as per circumstances of each case. And finally, in para 40, the position of law is that the stay of the letter is desirable.
So here, in my case, also, there is no wrong, my lord, in simultaneous proceeding.
Have you seen the latest judgment?
I have not gone through it.
You have to.
Let me know Friday, my lord. After going through it, my lord, I will send.
And last occasion also the government advocate appeared and said that we have received a copy on last 3 days back.
And 22, my lord, 2022 3SLT cases, they are discharged into division bench. Completion of departmental proceeding, court declined to interpret with the departmental proceeding and directed to complete the departmental proceeding suit. That was the also direction was there in division bench.
For reasonable time, it should be suspended.
The permanent proceeding has already been initiated, but let it be complete.
This is with reference to clause in a memorandum.
Clause of memorandum, but the law has been said that for time being, it should be said not for indefinite period, but it should be
Which paragraph again?
Look.
Which paragraph again?
finally para 40 Lordship.
No, para 40, no, but
It start from para Lordship will find para 22 onwards. Para 21, Paul Internet's case has been discussed.
so in so far as the stay is concerned,
Time being, for time being, not for indefinite period.
it has not overruled Paul Anthony.
No.
It is not overruled.
Not overrule.
Then?
No, he is saying overrule. I'm saying not overrule.
Okay.
No, Paul Anthony, they say the parallel proceeding is bad. That is Supreme Court says, this is not bad. It is erroneous decision. Yes, my lord.
Now show us the proceedings here.
Lordship will kindly see. Page 31 is a so cause. Page 31, Annexure 5. And thereafter, Lordship, the disciplinary proceeding. I have given a so cause reply. And thereafter, Lordship.
Who was the allegations?
Allegation is, Lordship, one trap was laid. I'm an
Are
investigating.
you in a hurry?
No. I'm an investigating officer.
Take us slowly through the allegation.
Allegation is, Lordship,
Yes.
while paragraph 2, Lordship.
Hmm.
While you are posted as Circle Inspector Simla, once the Dildar Hussain, Tajuddin Ahmed, Project District Man, a written complaint to SCB PS Assam, stating that on 3/5/2020, 12 o'clock in the midnight, police team under the leadership of Hirot Paul Choike as DPO, Salbari along with you and IC Simluguri conducted search in the residence of the complainant's father-in-law, Nayab Ali Ahmed, situated at Borpeta Road, Rezupot, seized few bags of fertilizer, not few bags, 8 trucks of fertilizer. The complainant mother-in-law, Rashmaria Ahmed, was arrested and forwarded to judicial custody in connection with Govardhana PS case number 1. In order to release her from bail from judicial custody, bail application was filed before the learned court. Accordingly, the case diary of the said case was called for by the learned court from you being the investigating officer of the case. You contacted the complainant and demanded bribe amount of rupees 5 lakhs. That is the allegation.
For sending
the case diary from the court. But complainant could not give the demand amount for which he did not send the case diary to Honorable Court on the date fixed. Honorable Court released the complainant mother-in-law without perusing the case diary and same came out from jail on 12/5/2023. After that, you have started putting tremendous pressure on the complainant's father-in-law. You asked complainant and his mother-in-law to meet you in the official residence situated at PP compound. According to on 28/5/2020, when the complainant met you, you demanded for amount of rupees 5 lakhs for removing the name of his mother-in-law from the charge sheet of the case. When the complainant expressed his liability to give the such amount, the demand bribe was reduced to rupees 3 lakhs and makes 50,000 as part demand of the bribe. On 29/5/2023, and also asked to pay the remaining amount of rupees 2,50,000 within next 7 days. And money has been kept in my table, and thereafter I have been arrested. That is my reply.
Where is the charge sheet file?
Charge sheet Lordship will find. Lordship will find CCD investigating officer has been appointed, page 40. Lordship. Page 40, the appointment of.
No, in the criminal matter.
No. Criminal case charge sheet has not been filed.
And then,
Criminal case charge sheet has not been filed. It is under process. Same fact, same allegation. That is why Lordship.
no, but same fact, same allegation. The
Given a-
departmental,
And I have already given a show cause reply stating that money has not been recovered from me, money has been kept in table, and thereafter I have been arrested. Lordship, fertilizer has been prepared by stone dust and color. I have seized 8 trucks of fertilizer from Borpeta Road. Thereafter I have been, Lordship, to remove me from the investigation, everything has been done. Lordship, urea is manufactured in Namrup. Here, Lordship, Borpeta Road, urea is manufactured. Superphosphate is manufactured by stone dust and the Lordship, the color.
That is good, but
Huge scam is going on. I have discovered, I have seized. That is why the huge, Lordship, this, everything has been done.
what is the stage of the DP now?
He can say, Lordship.
Malad,
Departmental proceeding?
Departmental proceeding, Lordship, inquiry
Started.
officer has been
inquiry
appointed.
officer is appointed and presiding officer also appointed. There is no lapse
I
on
have
the ballot
appeared- I have-
proceedings.
I have
There
appeared
is
to
no
the-
proceedings. What prejudice is ballot participating in the departmental proceeding?
I have participated, Lordship.
Then
I have
why he should be stay
participated.
ballot? Why
Which
he should be stay ballot? He should participate in the ballot departmental proceeding and do make cooperation with the inquiry officer.
I am
That is enough
cooperating,
ballot.
Lordship.
And
What is the stage of the inquiry proceedings?
inquiry proceeding ballot departmental proceeding ballot going on ballot. So it will complete within short period because they have already been started it. Inquiry officer was appointed, presiding officer was appointed. There is no procedural lapse on the part of the authorities ballot
I'm
in
not-
holding the departmental proceeding.
I'm not
Now,
holding that.
how he is prejudiced ballot in participating in the departmental proceeding? Suppose it is not stated by lordship.
Unless we know what are the charges in the criminal case.
Criminal case, same offense, Lordship.
There is
FIR.
no.
Maybe the offense, but how do we know they're on the same?
Lordship can see the FIR.
Exactly, my lord.
FIR is a different issue.
FIR is page, Lordship will find page 25 is the type copy and page 24 is the Lordship. 23 is the original copy, type copy. Lordship. Page 23. Same facts.
The affair.
You apprise the court on what is the stage of the criminal
Yes,
proceedings.
Lordship,
I looked at
witness has been examined. As per my information, the witness has been examined and I have filed application to get defense evidence.
But you said charge sheet has not been filed.
Charge sheet, there is why so-called represent charge sheet in criminal case. Lordship. Charge sheet
We
in
want to know what is the status in the criminal matter,
criminal matter charge sheet has not been filed.
not filed.
Not filed.
You get the instruction.
I
If filed, you place it before us.
yes, sir.
The judgment which you are referring is not applicable here. The judgment relates to a memorandum of settlement with the bank.
No, no, not memorandum settlement, but law, Paul Anthony has been discussed.
Law, you'll have to refer to the relevant judgments which are, there's only a reference. You'll have to refer to Paul Anthony and the others.
Supreme Court has categorically stated, my lord, categorically stated
Where?
that when, Lordship will kindly see again. From para 21, Lordship kindly see.
Yes.
View taken in Mr. Paul Anthony's was referred by this court in month, para 22.
No,
As
but that is okay. We are not saying it is not. What we are asking you is why are you not referring to Paul Anthony instead?
Paul Anthony is there, Lordship. Paul Anthony has been placed earlier, Lordship. Kindly see Paul
We'll
Anthony.
take it up. Let him get the instructions.
Yes. Otherwise, Lordship, till then, Lordship, under the,
No, not till then.
then another thing, Lordship. Lordship, kindly see one thing. There are two prayer interim prayer. One is Lordship is aware already, Lordship has passed order that suspension has been reviewed within 90 days. Here, Lordship, suspension has been reviewed after 90 days, admittedly. So suspension cannot stand. Suspension cannot stand, Lordship. Lordship, kindly see from the apparent from the record, I will place that suspension has been reviewed after 90 days. Kindly see.
You, Mr. S.K. Goswami, Mr. T.C. Sutia, learned government advocate, will apprise the court on the status of the criminal proceedings initiated against the petitioner in connection with ACB case number 40 of 2023. Learned government advocate will apprise the court as to the status of the investigation and as to whether any charge sheet has been filed in the matter. And if so, a copy of the same be placed before the court. And the government advocate will further apprise the court on the, if any review in respect of the suspension of the writ petitioner has been carried on.
No, within 90 days. Review order is, I have next.
Already
Case
Department
42, I have next.
started, now
Review has been made after 90 days. Law has been settled by this court. It could be within 90 days.
It will be, Rafael Ali case, we will have to go through it, when it was informed. From the date of information, it will count.
No, no, no.
Yes.
Suspension has been reviewed within 90 days. The
we will see,
police court and division bench has
I'll place all this.
that it should be reviewed within 90 days.
Yes, it should be.
It should be.
But now the review was already done. It is
Review
not a
was-
case that review was never done.
No, no, review was done after 90 days.
Correct. We want that information before we pass an order. Let us find out what steps the department has taken.
Lordship, I will produce the order by which suspension was directed to be reviewed. Where Lordship will find suspension was directed to be reviewed after 90 days. Kindly. The committee for the suspension of review was made after 90 days.
Now, after 2 weeks.
Committee has been constituted after 90 days. Lordship, kindly see. I have collected the copy.
In view of the allegations against you, we are not prima facie satisfied that the order of suspension should be interfered merely because the review was not done under 90 days. More particularly when the disciplinary proceeding has been initiated against you.
I understand.
But we are not passing an order because we want the government to apprise us of what is the status. If they don't, then we pass consequential orders.
I am only the law point, Lordship.
Quite right. We'll
only
decide
the law point.
we'll decide only the law points. But these law points will have to be understood on the facts presented.
Lordship. Law point, Lordship, regarding review of the suspension order, if it is not done within 90 days, suspension will not.
We are not rejecting your prayer. We are only asking them to give us this information because if they've not done, they cannot do it now. When can you give us, Mr. Sutia?
After 2 weeks, Malon.
Not 2 weeks.
10 days, because I will have to obtain instruction from the criminal also Malad Department of Proceeding.
From Guwahati itself, Lordship.
You are the mighty government advocate.
Sometimes what happens, Malad, it takes some time, Malad.
No, you get your instructions as early as possible, listed on 20 February.
20 February.
20.
Yes.
We'll consider your prayers. And we may even dispose of the writ
Lordship may
petition if
reject also my prayer, Lordship.
Huh?
Lordship may reject also my prayer, Lordship. Lordship is prerogative.
We may reject it, we may allow it.
Lordship.
But whatever we do, we'll like to do it on 20. Like to do it on 20.
Lordship may record interim order will again considered on 22, Lordship. Lordship, otherwise they will say it was not considered. Today was
Learned
fixed for
counsel for the petitioner is at liberty to press for the interim order on the next date fixed.
Obligation.
That is all. My lord, in this case, my lord, petitioner before your lordship was suspended. Page 10, my lord. He was suspended
Yes,
on 19/8/2023, my lord. Till then, my lord, today, my lord, it is not reviewed, my lord.
yes.
My lord, within a period of 90, my lord, suspension is at page 10, 19/8/23. So within a period of 90 days, a show cause notice with the charge memo of charges was handed over to him, page 49, my lord.
Page
49.
49.
It's in the affidavit, the additional affidavit which he has filed.
Yes.
So this was before the expiry of 90 days.
90 days. my lord. Then, my lord, they have to pass the, my lord, extension order, my lord. It is not done, my lord.
That instruction I'll have to get.
Oh. Is there. Then, my lord, Honorable Supreme Court's judgment, my lord, I have annexed, my lord.
Yes.
Starting from page 33, my lord. In my writ petition.
Para 21.
Para 21.
Yes.
Clearly, it is provided, my lord, even if, my lord, it is, charge sheet is submitted, then they have to pass the, my lord, review order. Within
But it doesn't have to be within 90 days.
No, my lord, lordship, page 45, my lord.
Hmm.
Paragraph 21, we therefore directed the currency of the suspension order should not extend beyond 3 months. If within these 3 months memorandum of charge sheet is not served on the delinquent officer employee.
In
If-
your case, it was served.
Yes, sir. I am on second part, my lord. If the memorandum of charge sheet is served, a reason order must be passed for the extension of the suspension order, my lord.
Correct.
So, my lord, they submitted charge sheet, my lord, but reason order is not passed for extension.
That is what he is supposed to apprise the court.
Yes, my lord. In this regard, my lord, I have submitted, my lord, one similar order passed by this.
I'll get
honorable
that
court.
instruction on the
Page-
next date, my lord.
My
My
lord,
lord, may fix it
kindly,
next week.
My lord, in this case, they have taken time on several occasions, my lord. Kindly, my lord, consider my interim prayer, my lord, because
Interim prayer, we will consider your final prayer.
so, my lord, apparently, my lord, they have taken time, my lord, on earlier
Have you
occasions.
received your subsistence allowance?
Subsistence allowance, perhaps, my lord. He has-
Perhaps.
Therefore, my lord, he has not, my lord, instructed me regarding that, my lord.
So which means he is not aggrieved that he must be receiving it. Otherwise,
Yes, my lord, subsistence allowance I am receiving, maybe presumed, my
heard
lord.
Mr. A.M. Borbhuya, learned counsel for the petitioner, Mr. Hendek, learned standing counsel, PNRD.
My lord, kindly
Submits
Friday, my
that
lord,
the
and complete
inquiry
telephonic instruction may be
focus
taken, my
notice
lord.
has been served on the petitioner within 90 days from the date of the order of suspension. He, however, submits that he is not posted with instructions as to whether
The suspension period has been extended.
the suspension period subsequently was reviewed, whether there was a review for extension of the suspension period. He prays.
Kindly, my lord, this Friday, my lord, they have taken time, my lord.
You first get your instructions whether you received
No, I
substance
am
allowance.
receiving subsistence allowance, my
You
lord.
just said you don't have
No,
instructions.
my lord, because, my lord, he has not tell me, my lord, obviously.
Presumption. Deep.
Yes, my lord.
Is
Because
deemed to
earlier,
have
my
received.
lord, this suspension order is passed long back, my lord.
Leave the matter on 5th of March.
My lord, it will take time, my lord. Kindly shorter date, my lord.
Why?
Only, my lord, only what I am praying, my lord, next week, my lord, because, my lord,
Why? If he is receiving subsistence allowance, he'll receive it. We'll pass orders.
I am away from the service, my lord, because I am affected, my lord.
You are getting subsistence allowance.
Yes, my lord. I am on against, my lord, suspension, my lord.
That's right. But you are getting your subsistence allowance, we deal with it, the matter.
Kindly, my lord, any
How are you prejudiced that it has to be taken up on Friday? Prima facie, it doesn't appear to be, they have served you a show cause within 90 days. in terms of para 21. Now, only question is whether any order has been passed.
On this paragraph, on similar judgment also passed by this honorable court that. my
We'll
lord.
pass judgments.
Yes, my lord.
Everything can't be done today. We give him some time.
Any shorter date, my lord,
Shorter date. All right, 20 February.
my lord. Deep double door.
Yes.
Matter pertains to non-payment of final payment as well as some.
Last occasion, notice was you were registered to my lord that bring the records of my lord that the final reports or my lord that yes, sir, my lord that proceeding is going on or not, my lord that criminal case first.
As per the order dated 1/12/2023, Lord. And thereafter matter again came on 18/12/2023, Lordship. On that day, Lordship, let us report. Came to come to the court, Lordship. It's a case of 1999, Lordship.
It has not been received.
Please,
Lordship.
In terms of the earlier order dated 18/12/2023, whereby status report in respect of any matter pending before the court of CJM, Kamrup Metro, in connection with Palton Bazar PS case number 189 of 1999, in which charge sheet number 121 of 2014 was stated to have been filed, was called for. Stop. Office note dated 5/2/2024 reveals that reflects that no such report has been received. Stop. The registry is directed to call for the report. The registry is directed to call for a report from the CJM Kamrup Metro as to the status of any matter relating to Palton Bazar PS case number 189 of 1999 is presently pending before the court, and if so, what orders have been passed thereon. Stop. The report shall also indicate whether charge sheet number 121 of 2014, which was stated to have been filed in the matter, has also been regarding the charge sheet stated to have been filed on so and so date. Charge sheet number 121 of 2014. Let a copy of this order be brought to the notice of Registrar Judicial. Let the report be placed before the court within the next 2 weeks. List again on 5th of March.
May I pray for a shortage?
No.
Petitioner is a-
Let the report come.
Cancel,
Mr. D.
Obliged.
for the petitioner, Mr. Hendik for respondent, Revenue
Lordship.
Department,
As for 1 and 3, Lord.
1 and 3. Huh? Yes, what do you want to submit here?
My lord, actually, some wrong submission was made, my lord. But actually here, my lord, we have not received the pension paper, my lord, from the department, my lord.
All right. Earlier, we passed an order at his submission that Mr. Mehdi says was meant for some other matter.
Yes.
So therefore, we adjourned this matter at his request, permitting him to obtain the required instructions from the department. You obtain the instructions.
Well, we have not received the pension paper from.
Who is supposed to send it?
Principal. Principal of the college, not service is already completed, my dear. Respondent number 4, 5, and 6.
4, 4, 5.
3, 4, and 5.
3, 4, and 5.
4 and 5, Lord.
Who's for the higher education?
Higher education.
As per orders of this court, custody service was effected on respondents 3, 4, and 5, and an affidavit to that effect has been filed. As per office note dated 4/8/2023. Today, when the matter is called up, Mr. H.K. Mary, Standing Counsel, Accountant General submits that the pension papers pertaining to the petitioner has not been received from the respondents 3, 4, and 5. Respondent 4, principal.
Principal Lordship.
Stop. In spite of custody service being effected, none appears for respondents 4, 3, 4, and 5. As such, we permit Mr. Das, Standing Counsel Higher Education, to obtain instructions through the Office of the Director Higher Education with regard to the status of the papers, the pension papers required to be submitted in respect of the petitioner by the principal to and so college. Matter be listed after 3 weeks. Yes. PhD.
Lordship. The age of superannuation of the petitioner, my lord, whether it will be 65 or 60. Petitioner will be attaining 60 this month, my lord.
What do you say, Amicus?
Let him complete his ballot.
No, the facts are similar that cabinet has taken a decision. According to the government, it is for academic.
Yes, well, the stand of the
That was the, Manoj, what happened at the hearing at length in the court of 5, Manoj. Court come to the conclusion that there is no arbitrary and there is nothing else. And court directed him to argue only on the point that it is a educational institution.
It was
But
hard.
I'll argue.
he did not, Manoj, argue this matter. That's why court has released from the pattern.
No, my lord, no. That
Yes,
is not
Lordship
the fact.
carries
It
the
was
order. I
released
am
for
not
the
saying
fact.
it.
It came to the notice of the court that petitioner is somehow known to the honorable court, my lord. Therefore, the matter was released.
Whatever it was released from Pattern.
Yes, Lordship, 30th, Manoj, 30th January 2024, recently, Manoj. Why? Court wanted to defer the matter as he did not, Manoj, submit like that to convince the court. The court wanted to, instead of dismiss the petition, Manoj, wanted to defer the matter. Then he argued that no matter his urgency is there, he is going to be retired. So that court released the.
When is he retiring?
He is this month, my lord, 29th of February. He will be attaining 60 years.
Simple things, Manoj, whether it is an education system or not.
I'll argue on that, my lord, without.
Where was the proposal? Have you placed the proposal by the department
No.
before the cabinet?
Oh, that is, Manoj, cabinet, Manoj, I think proposal may be there, but cabinet decision is with us.
No, cabinet decision is only
Lordship,
approval of the
told me,
proposal.
yes, what is the proposal? My lord, the cabinet decision is clear, my lord. That was also convinced by this court. My lord, clear only educational institution, including medical, and no research center, no others laboratory, all these things. Only things, my lord. And also, everybody replied they have arrest some 24 institutions. In a 24 institutions,
What is your designation?
Professor, my lord.
In the
Homeo Kumar Das Institute.
Mere professor nomenclature is does not, my lord, include it is a, my lord, educational institution.
My lord, my submission will be, my lord,
Let
every
him complete
research is also a part of education system in India, my lord, and research cannot be separated from the purview of education. To that extent, my lord, I am relying on the judgment of the Honorable Division Bench of Kerala High Court also, my lord, a recent judgment. And my lord, the new national education policy of 2022, I'll refer to that, my lord, where, my lord, much emphasis has been given for research in higher education system in India. Therefore, my lord, only because of the nomenclature, whether the institute has been named as research or educational institution, but that differentiation cannot be made. Otherwise, my lord, research is fundamentally a part of education system. Every education institution may not be a research institute, my lord, but all research institute is necessarily an educational institute. And the plea that has been taken on affidavit by the state and also in the argument is that the institute is a research institute. So Lordship will have to see whether such classification solely on the basis of research and educational institute, whether it is a reasonable classification or whether such classification has any reason.
Is there a definition of educational?
No, my lord. No, there is no definition. Only definition I have found in the Black Law Dictionary, my lord. Without any statutory definition excluding research institute from the purview of educational institution, my lord, the classification will be wholly arbitrary, my lord.
Is there any reference under the UGC norms? Under the UGC guidelines?
My lord.
Or the UGC rules? Is there any reference as to what is an educational institution, what is a research institution? Because
no
UGC
categorical
standards,
classification is not there.
are the UGC guidelines applicable here?
No, my lord. UGC is not directly applicable to the institute. It's a separate institute. And Lord, we'll see on the right hand side, my lord, educational institution, a school.
That is a very general definition.
My lord. So, though not necessarily a chartered institution, but that does not exclude. There is no statutory definition of educational institution which excludes research from its purview. So, Lordship may kindly take a look at the new education, so national education policy, my lord.
So these are not relevant. What we want to know, your definition is, that is why we want to look into the proposal, which was put up before the cabinet, Mr. Sutia.
Yes, sir.
That proposal, if you have.
Yes. Before
So-
before taking the decision in the cabinet, what is the proposal?
What
provided
is
by
the proposal that we
Yes.
want to see? And perhaps in the proposal, there is a reference that professor in universities, schools, etc., the age of retirement should be extended.
Yes, like in Guwahati University Act. This is the act, my lord. I have gone through it. This is a different thing to tell the research
Even
institute.
if, my lord, my respectful submission, even if that proposal is not there, my lord, the term educational institute itself encompasses research institute also. That is my respectful submission.
On the basis of a definition in Black's law.
Otherwise, my lord, there is no statutory definition, my lord.
We
In
don't-
absence of any statutory definition,
That is for you to argue.
my lord,
That is for you
that
to
is
argue.
why I am referring to National Education Policy of 2023, which has been approved by the Union Cabinet recently, my lord.
What
where-
does it, to what do you refer here?
My lord, the role of research in education system in India. That
Where?
is- Lordship, just a minute. It was approved by the Union Cabinet on 29th of July 2020, my lord. Okay, paragraph 1, paragraph 2, Lordship, world is undergoing a rapid change in the knowledge landscape with various dramatic scientific and technological advances such as rise of big data, machine learning, and artificial intelligence. Many unskilled jobs worldwide may be taken over by machines, while the need for a skilled workforce, particularly involving mathematics, computer science, and data science, in conjunction with multidisciplinary abilities across the science, social science. My lord, this institute is also a social science institute, my lord. Lordship, kindly turn to, my lord, one paragraph, my lord. The whole, I am not troubling your lordship. Lordship, I turn to paragraph 30, page 33. Many references are there, my lord. I'll just place some relevant part, my lord. Part 2. Part 2, higher education. Lordship, come to clause, may kindly come to clause 9.2. Some of the major problems currently faced by the higher education system in India include, Lordship will see G, lesser emphasis on research at most of the universities and colleges and lack of competitive peer-reviewed research funding across disciplines.
See, the question is not whether your status is recognized or not recognized as a professor. The petitioners. Question is, where are you employed? You're not employed in a university.
No.
This is a society.
Yes.
It doesn't come under the government directly.
There is no
It is
statutory-
not a part of the university. You are not a regular professor of the department or of the university sent on deputation for looking after the affairs.
Yeah.
You are a person who have been recruited by the society by following the recruitment process.
Yeah.
While recruitment, there is a set of rules for employment.
Yes.
These rules will govern you.
Yes.
You have accepted that
No, no, rule does not say it is 60. It says that it is 60 or as notified by the government.
as notified by the government. Now the
Yes,
government,
has already notified for professors to be 65 years, my lord.
Yep, that's right. So
But that interpretation is required
that
already.
interpretation, therefore we wanted to see the proposal. How has it been placed before the cabinet? I recollect in the last hearing also, we
Yes, my lord.
wanted to see that proposal. Where is that proposal? Why are you not showing it to us?
My lord, I wrote a letter, my lord. They have sent only the cabinet decision. And the proposal was, I think, my lord, the old one. I don't
You
think.
please request them to specifically
Yes,
send
yes.
the proposal which was placed before the cabinet,
Yes.
cabinet memorandum
Memorandum, my lord. Proposal, my
or
lord.
cabinet memorandum.
Cabinet memorandum. Cabinet memorandum is there, my lord, but the proposal.
Cabinet
provided by-
memorandum is there.
Yes.
Where is it? Let us
Cabinet
see.
memorandum, the decision of this, yeah, my lord.
Let us see.
Yes, it is, my lord, our affidavit also, my lord. Oh, it is in affidavit.
You provide, your professors act as guides for PhD scholars.
Yes, my lord.
You
There are
confer PhD
already
degree.
4 PhD petitioners under the petitioner. 4 persons has been awarded PhD under the guidance, and presently 3 has been awarded. 4 are pursuing. My lord.
No. The institute is not authorized to issue the degree.
Institute, it is issued by Dibrugarh University. My lord.
Dibrugarh University. You are affiliated to Dibrugarh University.
Dibrugarh University.
There is a, my lord, with Dibrugarh University and.
Is there any memorandum or understanding with the university?
Yes, my lord.
Yes,
There-
yes.
It is there, my lord.
Everybody replied there.
Lordship may take up the reply affidavit, additional reply affidavit, my lord, that 451.
Yeah.
Oh, Haru ki baat.
There is a separate affidavit file, lord.
Hi. 451.
451.
Memorandum of understanding for academic collaboration between Dibrugarh University and Omiyo Kumar.
This is the recent one, my lord. Prior to that also there was, we have annexed the recent one.
Also, can you see the purpose?
Let's see, it.
Yes, sir.
Yes.
This is memorandum of understanding for academic collaboration. Also, can you see the purpose? Dibrugarh University is an affiliated university which awards degree of Doctor of Philosophy PhD, and whereas Omiyo Kumar institution is an autonomous research institute of ICSSR and Dibrugarh University. ICSSR and institute
Has already
Dibrugarh
recognized the
University
institute as
has
a
already
research.
recognized as an institute as a research center in the arts and science. Already recognized as a research center, not an education institute, OKD, as affiliated research institute Dibrugarh University to undertake full PhD program, fully adhere to the Dibrugarh University regulation for a research council and for a degree of PhD. The Dibrugarh University and Omiyo Kumar Institute to recognize that mutual collaboration given each other's strengthens the teaching and research will mutually benefit the students and faculty of the organization. Collaboration affidavit. B. Recognize Omiyo Kumar Institute is recognized to so and so as a recognized research center of Dibrugarh University. Only research center. You do not say that it's a wing of the educational institution, Dibrugarh University. Say nothing. The Omiyo Kumar Institute is the wings of a Dibrugarh University. This is the point thing. It's not a wings. There are a mutual understanding only. How they will send basically the Dibrugarh University will send a student, those who are doing PhD for their guidelines. And they will supervise. Their professor will supervise only. There's no teaching position at all in the Omiyo Kumar Institute. That's why it is not an educational institution. They cannot confer any degree, any diploma, whatever may be. And there is no regular calendar of students.
You come to page 453.
4, 5.
Roman 4A, 1, then B1,
Yes, my lord. Responsibility.
then B2,
Students for PhD program. Page 454.
54. Yeah, no? Page yes. 2. Abhiyo Kumar Institute shall admit the student for the PhD program in the relevant subject through DURAC and as per provision of the regulation concerned. That is there, my lord, only student those who are doing the, my lord, PhD after passing the MA degree, after having the certificate from the university or colleges, they are doing the PhD and they will be sent by the Dibrugarh University to that institution for guidelines, only guidance.
kindly look at B1,
Then, and the
capital B1.
Yes, my lord. For research council for degree of
D.
Page 453.
Last. My page is B.
B1.
B1. It shall conduct a full-time PhD program in compliance with the Dibrugarh University relation to Research Council for the Dibrugarh PhD. Yes, full-time program to the PhD.
How will it conduct? How will you
They
conduct?
will not provide any degree or diploma in the PhD also. They will train also. The degree will be conferred by the Dibrugarh University.
On what basis?
That is, they will train. The student
Will train.
The student will send to the
For what purpose?
for PhD. Research.
So it must be done by competent persons who are competent in their subject. You have recognized, Dibrugarh University has recognized it.
My lord, even a school does not issue certificate. Certificate is issued by SEBA or CBSE. Whether by itself will exclude the school from the purview of educational institute.
Whether,
College also does not confer any degree, my lord.
what is ICDS?
Yes, my lord, we'll see that, Lordship will kindly turn to page 455.
ICSSR.
ICSSR, my lord, this is
400?
On behalf of them.
400?
455.
55.
ICSSR and my lord, Government of Assam has funded the institution. It's a joint undertaking.
No, what is ICSSR? That is
Indian
what I-
Council for Social Science Research.
Oh, so what does it do?
It promotes research.
Is
in
it
social
what?
science.
Is it another autonomous body?
Autonomous body, my lord, under Ministry of Higher Education. Earlier it was Ministry of HRD, now it is Ministry of Education.
ICSSR, it's a registered society under the Societies Registration Act. And it is an autonomous body under the Ministry of Education, Government of India.
What does it do?
But
They promote research in
our
social science.
kindly come to the affidavit, my lord. The affidavit we have filed.
Page number?
Respondent number 4, affidavit in opposition filed by the respondent number 4. Lordship will find at page 301. my
Respondent
lord.
4. Yes. Respondent 4.
Respondent 4.
Yes.
The paragraph 5, page 302, we have stated that it is an autonomous body and a registered society under the Societies Registration Act. Kindly come to next page. no?
Where is your MOA and rules of
Yes,
the council?
It is there. no?
Where is it?
It is there.
It is mentioned as paragraph 6, my lord.
Page 318, 318.
318.
Look, I'll take your lordship
This
to
is
that.
granted. The MOA to
No, MOA of the
But
MOA is
society.
mentioned, my lord.
but the
At paragraph
303, kindly come to 303. Let us one by one. no?
303.
Yes, Malab. Malab, the object 3, we have quoted, Malab, the object for which the council is established. We have quoted that. Can you come to 303? Malab? But the rules and memorandum of association and rules of council were approved by the Government of India by the then Ministry of Education and Social Welfare, letter number so and so. Clause 3 of the memorandum of association of ICSSR provided for various objectives for which the council was established. The object of the council as prescribed under clause 3 of its memorandum of association were as under
The object for which the council is established are to review the progress of social science research and to give advice to its users in government or outside, to sponsor social science research program as well as research project and administer.
Can you produce a copy of the memorandum of association?
Yes.
If you have a copy? Is it available? It must be available somewhere in the web portal.
Yes, I can,
I'll also try to
provide,
find
I can provide, that. I can provide that. The memorandum of understanding of the Omyo Kumar Das Institute is also there.
No, it is there.
Yes, Malad.
Hmm.
But this I can provide, Malad. This I can provide. We have quoted, Malad, the copy we have not done.
Are you, what is your stand with regard to the prayers made by the petitioner?
Our stand is that it is number one, Malad, it is up to the state government and it is for the respective state because the 24 institutes.
You have no role. You have no role to play.
Yes, 24 institutes are similar institutes are in this in the country, and all the institutes they are having different retirement
As per the state government.
as per the state government, and since the government has said that this is not an educational institution, and they are not extending the benefit, that is the nature they have. In fact, the petitioner they have sought the benefit of the UGC, the regulations. The higher education department, they have extended the benefit to their professors under the higher education department. The government has taken a clarification from the higher education department. Higher education department in their clarification has categorically explained why this Omyo Kumar Das Institute is not an educational institution.
Where?
That is Lordship will find in the affidavit filed by the institute.
By the?
By the response number 5, 6, and 7. 5, 6, and 7. Kindly see page 298. First, kindly come to 298.
298.
298. This is the Transformation and Development Department. They have intimated. The next page is the note, Malab. $299. As per discussion of the cabinet on 19/9/2012, the age of retirement of all professors of the educational institution, including medical colleges, was raised to 65 years. It is observed that Omyo Kumar Das Institute is the only institute in the Northeast which has the mandate for advanced studies and research in the areas of social science and therefore needs to be nurtured appropriately. Advanced level teaching, training, and research are the mandate among others. It teaches courses as prerequisites for PhD research over 1 year, over 1 2 year, 2 semester as per UGC regulation, but the institution itself offers only certificate course. However, whether or not Omyo Kumar Das Institute qualifies as an educational institution should have ideally been indicated in its initial resolution or memorandum of association when the institute was established. As per the aims and objectives of the memorandum of association of the Omyo Kumar Das Institute, it appears that the institute is specifically established for research and training education. Education is not mentioned. The institute has also entered into MOU with Dibrugarh University for academic collaboration. In the MOU, the Omyo Kumar Das Institute is described as autonomous research institute and recognized as affiliated research center of the university. There are other affiliating research institutes of the DST and under the Government of India Research Organization like ICMR, TSIR, etc. in the state, which are also recognized by universities as research center for conducting research programs. However, they are not considered as educational institutes as they are not degree, diploma awarding institutes. Retirement age for all in such research centers is 60. For an institute to be recognized as an educational institution, administrative recognition affiliation is required from the appropriate authority, such as the state central government, university, UGC, AICTE, or any other such statutory body. In view of the above, the administrative department concerned may perhaps take a final call on whether or not Ome Kumar Das Institute is to be considered as educational institutions for increasing the retirement age of its professor up to 65 years within the ambit of the aforesaid cabinet decision.
I think this is fairly clear. This is what they want.
Yes,
My lord, that decision, my lord, nowhere says, my lord, that decision was given to the respective department. Department is saying.
See, Mr. Counsel, the issue is on a very short campus.
Yes, my lord, absolutely.
Whether you are educational institute or not. According to you, you are, because you are doing research, you are getting
My
PhD.
submission is that research is a part of education, my lord, cannot be read in isolation, or there is no statutory definition which excludes.
You'll have to have some basis to make this argument. Reference to some judgment, some law, some findings. You cannot make a submission on the ground that on facts, this is what you want to submit.
On exactly on, not on similar fact, but on a different fact. My lord, the division bench of the Kerala High Court has stated that research is an integral part of education. My lord. That is the division bench judgment of the Kerala High Court. My lord. Although here the matter relates to recruitment, and what happened, my lord, the period undertaken for research, it was taken as education. It was put to challenge. Petition was initially dismissed, and in appeal, my lord, the decision has been reversed by the division bench. Lordship, the court division bench has framed some issues, my lord. Lordship may kindly turn to page 5.
So let us first see what were the issues here.
Recruitment to assistant professor. Lordship will find at page 5. The issues that arise for consideration.
Yes.
Issue number 3 at page 6, my lord. An answer to this issue, Lordship will find at page 8, paragraph 24. May I read, my?
Yes.
As regards the period spent by the appellant while on deputation to the Kannur University as Director of Student Services Project Coordinator of the National Service Scheme, we find that learned single judge has essentially relied on affirmance in the counter affidavit filed by the appellant in the writ petition, where she had averted that her job did not involve any teaching in the strict sense, to hold that the period spent on the said deputation cannot count towards teaching experience. In our view, the answer to the question as to whether or not experience gained by a teacher while on deputation to a non-teaching post qualifies as teaching experience must depend upon the nature of activities undertaken by the teacher in the post to which she is deputed, and not merely by the classification as teaching or non-teaching. Accorded to the post, it cannot also be determined solely on the basis of the averment in her affidavit, where she has merely stated that there was no teaching in the strict sense. In this case also, my lord, the respondent in affidavit has stated that there is no teaching purpose, only research activities, my lord. Paragraph 25, the scope of the phrase teaching experience can be determined only through understanding the true nature, scope of the word teaching or pedagogy itself. Changing conceptions of learning bring along corresponding changes in the conception of teaching. We have already alluded to transformation in the models of higher education, noticed globally from the Humboldtian model to neoliberal model to an electric mix of both in more recent times. The model of higher education pursued in our country can be glanced from the perusal of UGC regulation as well as national education policy in vogue. That, Lordship, I have placed before your Lordship national education policy, my lord. Exhibit so-and-so, document to which extract of the national curriculum framework and guidelines published in the UGC so-and-so, so-and-so. So finally, my lord, this court, Honorable Division Bench, has held that research, that appellant was on deputation for some research activities, that part was direct to be included as teaching experience, the period in undergoing research. In fact, my lord, in this judgment also, the period for postgraduate, the PhD time frame spent in PhD, that was also taken to be considered as research program, my lord, for teaching purpose by this judgment itself.
Yes.
I have not found any other judgment except this, my lord, whether that distinguishes educational
You have
institute.
not found because there will be no judgment to that effect. What
Yes,
we
my
want to find out is how do you correlate
Yes, my lord.
research
Yes, my
with
lord.
education.
And in fact, I have also not found anything which excludes research from the purview of education, my lord.
So whatever you have found, you should give it to us.
Yeah, that's what, my lord. I have found the National Education Policy 2020, which it has also been referred, my lord, where much emphasis has been given to research, and pursuant to the National Education Policy, the UGC framework that has been provided to your lordship, where emphasis has been given on research, my lord. And these institutes are basically research institutes that is admitted, my lord. But whether that excludes education, whether research is exclusive of education, my lord, that is the issues to be decided by your lordship. Can the distinction be made only on the ground that we don't give any degree or diploma, whether our activities are similar? Even a school does not give any degree or diploma, my lord, can it said to be not to be an educational institute?
So schools are different.
Yes, my lord.
Come
This is,
under a
they had
purview of
the stand of the respondent
statute or an
state.
act.
The stand of the state is that
There is a particular act or a set of rules which
Yes,
defines how a school is to be established, the registration, etc., etc.
So this is the
So
argument.
that
this is the-
analogy cannot draw it here.
Yes.
See the problem is it's in this Kerala High Court Division Bench judgment is with regard to counting of your experience which
Yes,
you had rendered.
Yes, whether
it can be a teaching experience.
Yes, the similar to the
But-
analogy, my lord.
No, not similar. It is just the reverse. You want to show that because the experience in research can be counted towards teaching experience.
Here, issue number 3 is similar, my lord. Before lordship goes to the judgment, the period undergoing in research was taken to be as research experience, my lord.
That is one way.
Reading, teaching experience.
But whether the period, whether merely because you conduct research, will it convert the institute into an educational institute is an entirely different issue.
But that is in my respectful submission.
It is an entirely different issue.
Yes, my lord. But that may not be relevant for the fact that since the purpose of research is a part of education, my lord, we are not doing any different thing.
Absolutely, absolutely, we agree with your submission. But whether that by itself will convert this institute into a research, educational institute,
That conversion is not, my lord, even if it does
will
not
be
convert,
treated to be an educational institute.
but only to the extent of the benefit of age of superannuation, my lord, my answer will be yes, my lord. Not for other purpose at least, but only to the extent for age of superannuation of professor, then my answer will be yes. Not for any other purpose.
Yes.
And there, in fact, my lord, there is nothing on record to show any statutory definition which exclude. Any policy decision to exclude is always subject to your lordship judicial review, my lord.
No,
Whether-
no. Policy decision is policy decision. Unless you show that the policy decision is a colorable decision which
Yes, that
requires
policy
interference.
decision, my lord, is
The policy decision may be good or bad. We may disagree with the policy decision,
Yes,
but
that
that
policy
does not
decision.
necessarily mean that we would like to interfere. Unless we are certain that there was a deliberate attempt to exclude this particular institute
yes,
from
but
the
if
purview.
that is that I can show, my lord. If that I can show, my lord, from one document.
What about
Lordship will kindly come to
what
page
about engineering colleges?
65, my lord.
Engineering is in terms of this policy decision included.
Yes, my lord.
Well, kindly have a look at the read petition, page number 78. Page number 78. And in fact, this is the decision they are relying, and they have made a prayer for giving the benefit of enhancement of age.
No. My query is, this decision says all professors of educational institutions, including medical colleges.
Yes, my lord.
So it includes engineering colleges also.
Colleges.
Yes.
Professor, only professors. Professors.
In fact, my lord, for medical college now it is 70 for professors.
It's a different thing, my lord. But this is by the higher education department, and it was directed to all the vice chancellors of Guwahati University, Dibrugarh University, Cotton College State University, and all other universities. In fact, one of the Assam Science and Technology University is also there. So this is professor of educational institutions, and therefore the department, the administrative department has sought a clarification from the higher education department. And placing reliance on this 26 September 2012 decision later, they have made their prayer at page 40. Yes. They have prayed that inter level that mandamus shall not be a writ in the nature of mandamus shall not be issued, declaring and holding that the age of superannuation of the petitioner shall be as per the cabinet decision of the state government adopted on 19/9/2012 and the notification dated 26/9/2012 issued in pursuance thereof regarding the age of superannuation of professor.
Yes. Okay. And anything else?
One more document I wanted to place
Well, the
regarding the differential
Respondent number
treatment.
5 institute, I'm adding one sentence about. Respondent number 5, the institute, it's a registered society, it's a registered society under the Societies Act. In fact, the respondent number 4, this is also an society. And they have only adopted for their pay, they have adopted the UGC norm, UGC pay scale. Otherwise they are depending on the fund of the ICSSR and central and the state government, and 10% from their own pool.
Please show us the what do you call the memorandum of ICSSR?
ICSSR, I have to place one. I'll
You get a copy, let us.
Yes, I'll place that. I'll place it.
Yes, what document?
Lordship, the additional affidavit, my lord, reply affidavit, two documents, in fact, my lord, page 455. Lordship has already perused the MOU with Dibrugarh University.
Yes.
455. This is a communication issued on 30th of November 2010. It was issued by the Ministry of Human Resource Development at that point of time, my lord. Now, to the Member Secretary, Indian Council of Social Science Research. The matter relates to implement of 6 CPC, my lord. Lordship, kindly turn to page, my lord, 457. Some terms and conditions were imposed, my lord. F, my lord. Lordship has found F.
Yeah.
Yes. The pay scale and allowances of the academic post, qualification, recruitment rules, etc. should be as per UGC norms or state university norms. The case of the petitioner from the inception is that it should be as per state university. In Assam, one of the state universities' age of retirement is 65. Therefore, that age of superannuation is also applicable to the institute concerned, my lord. In fact, my lord, this has been clarified in the year 2010 itself by the central government, the ICSSR. And the name of the institute, lordship will find that next page, my lord, at serial number 18, Homiya Kumar Das Institute. Lordship has got it, my lord. And in fact, my lord, institute on several occasions has made many representations before the state government for raising the age of superannuation. And to that effect, lordship may kindly see page 459. With reference to the letter on the subject cited above, I am enclosing herewith the age of retirement of all 24 research institutes under ICSSR and the respective state government. Lordship, may kindly turn the next page. There are 24 research institutes, out of which 4 are 100% funded by ICSSR. In their case, for professor, it is 65 years. And in respect of others, my lord, whatever is in the state university, that is followed. For example, in Karnataka, my lord, still age of superannuation of professor is 62 years. That has not been enhanced to 65. Therefore, my lord, it is in Karnataka, it is 62 years. Similarly, in West Bengal, it is 62 years. Bihar, 65 years. But in Assam, that is the discrimination I am trying to place before your lordship. That in Assam, already state universities, the professors are retiring at the age of 65. But the institute
Where is the order rejecting your proposal?
There are 2 orders, my lord. One, first order, lordship, kindly give me a minute. (205) is the last one, my lord. It was issued on 9th of August 2022. With reference to the letter on the subject cited above, I am directed to inform you that the government in Transformation and Development Department regrets its inability to agree the proposal for raising the age of retirement of Professor of Homiya Kumar Das Institute of Social Change and Development.
Where is the order? This is a communication.
This is it was stated to be the order, my lord. And prior to that, my lord, there was one more order of 2014.
Yes, Mr. Sutia. If you come to page 205, it is an communication issued by additional secretary.
Yeah.
Communicating the rejection of the department.
Yes.
Where is the rejection of the department?
By this letter, my lord, they have communicated that your appeal is rejected.
That is what we just said.
With
Now, where is the rejection order?
Order is, he has not annexed here.
No, it will be available in the department.
300, no? 300, my lord, please.
300.
Yes.
300.
Yes. Proposal for raising of the so with reference to the letter on the subject of I am directed to inform you that the government is responsible department.
Same 205, my lord.
Huh? 9 August. 906. One letter is there.
There must be some order in the file. You get that order? Yes, okay.
Lordship, kindly see, their additional affidavit, my lord, they have already stated. They have annexed it, a reply. They have replied, the affidavit reply, my lord, 24 institute, all are
We are
different.
asking you a very specific query that in terms of the order at page 205, whereby the proposal was rejected. This is a communication.
Communication.
So where is that order for
Order.
rejection?
Yes, yes, I
It
understand.
could be in a note sheet, it could be a separate order. We'd like to see that.
Yes, yes. Ma'am.
What was the proposal, what was rejected? Yes.
But there are all the 24 institutes.
You have urged that point, yes.
Yes. And one more thing, my lord.
Hmm.
Lordship, may kindly see page, I'll trouble your lordship, my lord, page 136. My lord, what are the effect of non-increasing the age of superannuation to the institute? My lord, the aims and objectives, lordship, on the previous occasion, lordship has seen the aims and objectives of the institute for which the government of Assam and ICSSR has established the institute, Amiya Kumar Das Institute.
See, it is a policy decision.
Yes, I understand.
Policy decision has been placed before the tribunal, by the cabinet.
Yes.
Cabinet has approved it.
Yes.
Now, once a policy decision is taken, whether that policy decision includes research institute is an interpretation that you want us to do.
Yes, my lord.
Before that, we want to know what was there in the policy, in the
Lord.
proposal.
Lord.
That is not here. Where is that proposal? Where is the proposal which was cabinet memorandum?
Yes.
We want to see what was placed before the cabinet, what was considered,
Yes.
and
Order.
this order at 205.
And one more order is there.
It is not with me, my lord. I will obtain it.
Please get it.
My lord, may I kindly refer one, my lord, our additional affidavit, page 436. We annex a letter, my lord, the Government of India Ministry of Human Resource Development, Department of Higher Education. 436. It is specifically says, my lord.
Specifically?
Yes, specifically mentioned here, my lord. What is the position, my lord?
Page number?
436. 436.
436.
Our additional affidavit, my lord. Right?
Additional affidavit.
Has your lordship got it?
Yes.
To the Secretary University Grants Commission. It is, my lord, subject enhancement of age of superannuation from 62 to 65 years of teaching position in centrally funded institution in higher and technical education. Lordship, kindly see paragraph 2. The matter has been reviewed by the central government in the light of the existing shortage of teaching positions in the centrally funded institutions in higher and technical education under this ministry, and in the context of government decision to expand the capacity of such institutions for increasing access to higher education and to implementing the policy of reservation for the weaker sections without affecting the number of seats in the unreserved category available through general merit. Accordingly, it has been decided that the age of superannuation of all persons who were holding teaching position on regular employment against sanctioned posts as on 15 March 2007 in any centrally or funded higher or technical education under this ministry shall be increased from 62 to 65. And Lordship kindly see was 3. It is further clarified that the enhancement of retirement age as mentioned above, the provision of re-employment will apply only to persons in teaching position against post sanctioned to centrally funded higher or technical education coming under the purview of this ministry in order to overcome the shortage of teachers. These are the letter issued by the Deputy Secretary Government of India, Human Resources Department. So they have already taken it. These are not education institution, they are not any teaching position. So it is not a question of enhancing his age from 62 to 65. In fact, our additional affidavit, lordship, we have mentioned here one Indrani Dr. She was the earlier director of this institution. Then she was promoted to the professor. She is retired in the age of 60 years. I have mentioned it. So there is no, my lord, any objection regarding this matter, my lord. In the lordship kindly see our affidavit 431 page. Last page, paragraph 10, last paragraph. It was during petitioner's tenure as director of the institute, the Professor Indani Dotto retired from her service as professor of the institute in September 2017 at the age of 60 years. Professor Indani Dotto joined OKD as leader of the in the November 1995 with extraordinary leave from the Guwahati University. Department of Education and subsequently resigned from the Guwahati University on November 99 and remained in OKD. She was promoted as professor at the Institute of on December 2003 and retired at the age of 60 years from the Omio Kumar Institute in September 17. The age of retirement has never been a restriction in attending the quality professional institute. They are otherwise praying before lordships to death. Due to non-enhancement of the age to the 65, there is insufficient person found as a professor in the institute. That is not a matter. This Indranee Dotto, she was in the Guwahati University. She resigned from the Guwahati University and continued in the service in the Omio Kumar Institute. And she was retired in the 60 years. So, and their reply is also 24 in the affidavit reply. Affidavit reply, they have annexed here, Mala. Affidavit reply, they have annexed page 298 is starting from like and showing. Yes. Page lordship 459. No, 459. May I read it, Malo? Deputy return to the deputy state to the governor of
No,
Assam.
you bring that memorandum. We'll see after that.
These 24 institute, Malo, they have different.
Heard learned counsels for the parties. The respondent government is permitted to place before the court the cabinet memorandum on the basis of which the proposal for enhancement of retirement age from up to 65 was taken by the state cabinet for in respect of educational institutions, including medical college. Stop. The department will also place, government will also place before the court any order that may have been passed rejecting the proposal for raising the age of retirement of professors in OKD, Institute of Social Change and Development, as is reflected in the communication dated 9th August 2022. This is the matter again.
13th, my lord.
Not possible. No date before 20. Not 20, 22.
22. Any day before if possible, my lord.
No, if he retires, he retires. Whatever order we pass, if the benefit is to be granted, he will continue. If not, he'll not. What can be done now? We'll try, but we can't guarantee you that it has to be done before 28. 22nd. Based on 22nd. 13th, there are 54 cases for hearing. 15, there are 46 cases for hearing. 20, there are 100 and something cases for hearing.
I understand.
So the available date is only 22nd. So we are giving you the earliest possible date. And on that date, we'd also like to hear the amicus if possible. And any other judgments that you'd like to place on record? We are keeping this judgment. We are keeping a copy of this judgment.
Yes, madam.
We are wrapping it.
Documents get the matter as part heard.
No, not yet. We've just started hearing. Let us see. It's come up before 20. Yes.
May I pray, madam?
This is a matter where
Lordship,
they have not filed any affidavit as yet.
Lordship, we need some time. Lordship may grant some time.
Yes, any objections?
So they are taking time since long. It's in withdrawal of my gratuity on the ground that some proceeding is pending. But as per the rules,
We
there
will
should
give
be-
them 2 weeks further time.
Yes, ma'am.
And the prayer of the learned counsel for the respondent, MS so-and-so, matter stands deferred for 2 weeks, enabling them to file their affidavit. Mr. Bhattacharya appears for the petition.
Can I take 6 months?
Dr. Goswami appears for respondent 3 and 4.
4 months. We have filed affidavit, madam.
MS so-and-so for accountant general. Accountant general,
Lordship, I am appearing for respondent 1 and 2.
respondent 1 and 2.
Can I take 6 months?
28th of February.
Public.
Oblique Lordship.
Lordship, in this case, service already completed, Lordship.
Service completed.
Yes, Lordship.
As per Lozima Court Order dated 29/1/2024, service on respondent 10 is stated to be complete. Accordingly, matter be listed for admission after 1 week.
Obliged, Lord.
Yes, your lordship.
Yes.
As per official dated 29/1/2024. The IQ to take steps resolution number 4 and 5, lordship. Lordship, 2 days may be granted, lordship.
Mr. So-and-so, learned counsel for the petitioner is permitted week's time to complete the steps on respondent 4 and 5. Matter be listed after 3 weeks. None appears passed over.
When is supposed to bring the
Lordship,
today, studied last moment.
Lordship, here I have received instruction, Lordship. Lordship, this is regarding that giving retrospective effect of provincialization, Lordship.
Not retrospective.
Why this IAS file?
IAS file, other day, second
Rectification of the order, 7/11.
Conferred to the petitioner as per the order 1/1/2013. The annexa 1, is 14. First para, while conferring the benefit of provincialization, the order was that with effect on 1/1/2013. But here is the case, I approach this honorable court since there is initially at the time of provincialization, the dice name number was, some mistake was taken place. Subsequently, it was rectified. And dice numbers was conferred to the petitioner school way back in 2006-2007. Here, the school was, that is why a name was enlisted among the provincialization order. Page 15, serial number 1 and 4 is the name of the school, So, since there is an anomaly there, that is why the salary was not paid. That is why we oppose this honorable court, with a prayer to release our salary with effect on 1/1/2013. Annex 3 is the judgment.
Now
Annex 2 is the judgment,
this was amended. This was modified.
It was modified in a review case, but the word with prospective effect, that is page 27, para 12, quoted the para 12 of the petition, the order, the operative.
Where is the order dated 12/12? 12/12?
Page 19, Lordship.
Page 19, relevant portion is at page 23. the direction part.
But observation is at paragraph 5 and 6, Lordship.
Paragraph 12,
Five and
operative
6.
portion, my lord, that has been modified subsequently.
Paragraph 5 and 6 of the order is vital, Lordship. Yeah.
Vital on that that is why we approached the review court, my lord. On 12/12/2019, it's due to my lord, the entire city was paralyzed. In essence, on the learned counsel of the petitioner, the government, only government advocate was there. The case was disposed of without hearing us. That is why we approached before this honorable court by way of the filing the review petition, my lord. That is page, order is page 25 onwards now. While modifying the order of the writ petition, this honorable court, page 27, para 12, para 8, quoted they modified the para 12 of the writ petition as may I read, my lord? Accordingly, this court direct the authority to examine the phrase, the case of the petitioner school, keeping in mind that the provincialization order has not been recalled, and the cause of the school to rectify and deficiency if there are any, accordingly extend the benefit of the provincialization with prospective effect, mother. In terms of 2012 rule, 2011 act, mother. Well, prospective effect, well, there is a mistake because in the original order, mother. Original order, it is directed to confer that provincialization benefit would have come, that is page 14, Malad, would have come 1/1/2013. That is a mistake, prospective effect, otherwise they will not entitle anything, Malad. We approach this honorable court by way of filing the petition, review petition only because of we are not getting the salary in terms of the order. Anomalies was propped up initially that regarding the highest number of the school. That has been rectified, even though we are not getting. That is we approached the honorable court. So there's a no. That is why we are filing
in order 14,
my lord,
page number 14.
My lord.
Where are the names of the petitioner?
My lord, the next page, my lord, page 15, 114 serial number. Now we saw number 1 Hemagor LP school.
So according to you, since the names appear here,
my lord,
you are required to be granted the benefits as admissible from time to time with effect from 1/1/2013.
13.
Under the Act of 2011.
11. The act is already
Act was interfered with.
My lord.
Then?
No, act was that has been modified in the review order. In review order, it is clearly says that as per Assam Health Education Provincial Act 2011, as per that benefit that has to be given. But there is my humble prayer that prospective effect that may be a mistake, because we hear with effect from 1/1/2013, benefit has been given conferred to all these schools which were provincialized. Our school admittedly get the provincialization with effect from 1/1/13. So prospective effect it will be totally against us because we oppose this honorable court saying that in the writ petition our prayer is very specific. With effect from 1/1/2013, you'll see other day gone through that order, the prayer portion also. So that is why we are now in this order.
No, 1 minute. The order at page 14 was passed under the Act of 2011.
11.
By the time the writ petition was disposed of, 2017 Act had come.
No, there is another aspect. There's another judgment which says that if certain things was already done, admittedly our schools were provincial as per that order with effect on 1/1/2013. So due to these anomalies, there is a cropped up anomaly regarding the number. Last number of the dice code was mistakenly given 5 instead of 4. That has been rectified, modified subsequently. So our contention before this honorable court was that we are entitled to get the benefit of provincial with effect on 1/1/2013. The anomalies has already been rectified. And while dispose of the writ petition, definitely we are not, the councils were not able to attend the court due to car ban on that very date, my lord. So this was disposed of without hearing us. That is why this order
subsequently we prefer the review petition, that is Annex 3, my lord. So it is rectified that with effect as per 2011 Act, they are entitled to get the benefit. But that prospective word, my lord, it totally against us, and that is why, my lord, director now, in terms of.
What do you say, Mr. Sharma?
Although that provincialization order of 2011 was published in 2015, but there was a condition. Lordship, may I take your lordship to the order of the writ petition, page number 21, paragraph.
Come to page number 14.
Lordship, that is their lordship. Page number 14, the provincialization order. It was with effect from 1/1/2013.
Their names are
was a
there.
Condition
Their
that
names are there at
subject to
114.
fulfillment of the criteria.
Right.
And in regard to the petitioner's school, there was a mismatch of the dash data.
Right.
Which
Dash number.
Which fact has been brought on record by way of an affidavit in the writ petition. Now that has been elaborately explained.
That has been corrected.
No, lordship. That lordship may kindly peruse page number 6, paragraph number 6, page number 21. The official respondents have filed this affidavit in opposition in regards. It may be apprised opposite to refer to the affidavit in opposition filed by the respondent number 2. That is the Director of Elementary Education as well. The problem regarding the school has been explained by the director in paragraph 5 and 6 thereof, which are reproduced here and below. That the deponent states that the DEO Lakhimpur had submitted the proposal with the recommendation by the District Scrutiny Committee for provincialization of service of teachers in respect of number 1 so and so school to the office of the deponent. Thereafter, the directorate sent the proposal to the government for approval, and accordingly, the government had sanctioned the post against the petitioner school, and provincialization order was issued on 14/5/2013. However, there was a condition that no provincialization order will be given effect to in case of any land dispute, court cases, absence of dice code for the year 2009-10. It is therefore, it is stated that provincialization of service of post of teaching and non-teaching staff of the schools as per provisions of Assam so and so 2011 as amended 2012 hereinafter. Paragraph 6 is important, lordship. That after provincialization order was issued, it was found that the dice code as claimed by the petitioner was not matched with the dice data as collected from the SSA office. Kahilipada. The name of the petitioner school, that is so and so, was included in the list of doubtful and unmatched list with dice data code number so and so. The name of the petitioner was not captured in the dice code during 9-10 or prior to 2009-10, and therefore the payment of salaries of the teachers concerned was held up. In this regard, this directorate issued a letter on 31/12/2013 to the concerned DO not to release the salary to the schools whose names are found in the list of schools having doubtful or unmatched dice code data of 2009 and 10. Thereafter, the office of the deponent, by letter number so and so, requested the mission director SSA Assam to verify as to whether the petitioner school had the dice code for the year 2009 and 10 or prior to that, as required under the provision of 2011 Act, and to furnish their reports. It is stated that SSA Assam is competent authority to dice code to the school or to verify the authenticity of the same. Pursuant to the letter of the director, SSA Assam submitted report to the director, right number so and so data so and so, stating that the petitioner school had a dice data code only for the year 2013 and 14 to 2015 and 16, and not for the year 2009-10 or prior to, as required by 2011 Act. In the year-wise database, the SSA has not stated that the petitioner school had the dice code for the previous year up to 2009-10. Accordingly, it was stated that since the dice code for the year 2009-10 or prior to that was mandatory for provincialization of the school in terms of the Assam Venture Educational Institution Provincial Service Act 2011, since the petitioner's school did not have dice code for that year or prior to that, as reported by the SSA Assam, the petitioner's school was not eligible for provincialization, and as such, the teachers of the schools are not entitled to salary and allowances. It has been further stated that the said Act of 2011 had been already declared null and void by this court, and thereafter, the government had enacted a new act, namely, so in 2011, Assam Educational Provincial Service Teachers and Reorganization of Educational Institution Act 2017 for provincialization of services of teaching staff and ventures. However, this court has noted from the pleadings that
Mr. Goswami, you have put yourself in a very precarious position. See, come to page number 23.
Lordship.
Para 11.
My lord.
Para 11 holds that notwithstanding the dice code not being available in 2009-10, if there are any irregularities, government will consider, because your order for provincialization has not been recalled,
Recall.
will clear these deficiencies and pass order.
As
Will
a-
not allow these the deficiencies to come in the way of granting provincialization.
No.
Now, accordingly, this court disposed it of directly because provincialization was granted under 2011.
Well,
Prior to filing the writ petition or perhaps during the pendency, it was set aside. Set aside by a subsequent order.
well,
Provincialization
well,
Act.
on that,
Wait,
your
wait.
losses.
No, wait,
to
wait.
Satisfy your losses. My lord.
No, wait. It was
No.
set aside.
My lord.
But subsequent review filed, the court held that whatever provincializations were granted under 11 will be protected under the new act, will be considered to be deemed. So it is in view of that, the court held that the respondents will look into the anomalies and clear it, and thereafter grant you benefits prospectively under the Act of 2017, because 11 Act is already gone.
My lord, here it is. clearly
Now,
states,
now,
In
wait.
terms of 2011 Act, my lord.
No. Prospectively has to be read with 2017 because 11 is already gone.
My lord, page 27, my lord.
No,
Page
20
27,
no,
review
27
of-
comes later. Listen. Then what happens? You file a review. In that review, you point out that it should have been 2011, not 2017. That was corrected.
My lord, my humble-
According to my understanding, this order in page number this 24 doesn't require any,
my lord,
because you see, your salary with effect from 2013 will not be available unless the defects are corrected, which is what the direction
that
was
has
given.
already been corrected. In writ petition, entire documents are annexed by the writ
That is
petition,
not
my
the
lord.
finding.
My lord, that
That
is
is
why
not
we
the
oppose-
finding.
We oppose this honorable court by way of review petition.
The review
This
does
is
not,
on that
Mr.
he was
Counsel, what
expert
you
to
are,
order.
no, what you are submitting now
My lord,
will require a hearing of the writ petition. That order was never recalled. What was corrected is, instead of 2017, it is 2011.
my lord, we are in a difficult position.
You are in a
because-
difficult position, then you have to recall the whole order. You have to recall the whole order.
My lord, can it be?
We don't know
another day,
because,
my lord? Another day for further
all right,
consideration.
at the request of learned counsel for the petitioner, list after next week. But this is exactly what has happened in the matter. For some reason,
My lord,
the review was sought for, and only that year of the act was corrected.
it was, our hearing or understanding was that it will be definitely with effect from, the prayer was with effect from 1/1/2013. And
That
there
was
is a anomaly that
no,
already been clarified.
according to the understanding of the court, that prayer was not even required because your order has been upheld. And it is deemed to be protected under 2017 Act. So why is it necessary with effect under the 2011 Act? Not necessary.
But already we are in 2011 that 11 Act. Now 2017 Act cannot be, my lord. Otherwise we will lose everything.
No, that is the judgment. There's a judgment passed by the subsequent court while setting aside the 2011 Act in review. Whatever benefits are conferred will be protected under 2017. Yes, next week you go through it and see.
A specific date may be.
You take a date from the court master.
Mal.
Mr. Borua, some other date.
My lord, here, last order, what amendment?
Some benefits. Some benefits.
Increment benefits, disputed and undisputed amount. This lordship was kind enough to pass direction to at least to pay me undisputed amount, that is 6 lakh. By 30 days. That is from 20/11/2023. Accordingly, your lordship was kind enough to fix for hearing because your lordship was we are in good hope that within 30 days this amount will be paid. A hearing will be conducted for disputed amount.
Right.
But unfortunately, as on date, when your lordship was kind enough to fix on 1/2/2024, my learned friend was out of station. That is why today is fixed, my lord. My submission is, my lord, in spite of direction having direction from your lordship to pay at least undisputed amount, that is 6 lakh something for medical treatment of my wife. But it is not also not been paid. That is why your lordship was kind enough to pick the matter on columns of order. But unfortunately, this one it has not been again hearing for. Listen, that amount at least can pay me.
Why
my
is
lord.
it not been
Why
paid?
they are not paying?
To that extent, I have to take some instruction.
What instruction, my lord? How many days instruction will be taken?
It was a past, well
Yes,
over
yes,
2
order,
months.
fast order.
Some lapses on the part, my lord. And lordship will fix it next week, any day, my lord.
Fix a date on next week.
Otherwise, failing is, my lord, my humble prayer, because let
records-
officer comes and reply, because there he is also not cooperating with him.
Let the matter be listed again. Give a date.
He
Any
take
day,
it, you.
next week.
19th.
Huh?
19th.
19th. 19th.
19th.
Saturday, nahi?
No,
16 miller. Oh, no. All 14 miller or 15 miller. Because 16 I'll be out of station.
15 already, it can be on 16th.
16th I'll be out of station, or depot I'll be, that's why.
Huh?
I'll be out of station.
Okay.
Or another 2 days maybe given, Miller.
Then 21st.
21st.
Let it be on 21st.
First only there's a little observation, and it should be listed for order column. Columns in order, Miller.
22.
Okay.
In order column,
On
Miller.
22nd, my lord, Thursday.
Be listed for orders. Yes.
On 22nd, my lord.
Not 22nd, 21st.
21st, small, some personal difficulty, my lord. On 22nd, my lord.
No, not 22nd. We have difficulties. Then on 23rd.
23rd, my lord.
But
Yes.
that
Let
observation
me
should
come
be
up
there,
with the
Miller,
orders,
at
my lord,
least.
then it will reach.
Some hand.
It will reach anyway, whatever column, but you get your instructions why you have not done. Otherwise,
My
we
lord,
pass
my lord,
consequential
my lord,
orders.
My lord,
That should
There is a specific direction to release.
my lord, we'll get it.
Please get it done before 23rd.
My lord, we'll try.
The matter be listed on 23rd.
on column
At
order.
joint request. For
Highly-
orders.
Hello.
For
Hello.
orders. Yes. Aru ki baat?
In this matter, affidavit has not been filed, Your Lordship. Petitioners have not been given.
Who's for the
petitionary-
respondent? There are no respondents.
Secondary education was supposed to.
They are not here. Matter be listed next week. Obliged.